My lord, item number 1 on behalf of Mr. Pitambar Panda may be taken up next week.
As requested on behalf of the appellant, list this matter on 1 week.
Item number 2. Case admission item number 2.
Last occasion, you also had this matter. Why is that rehabilitation has not appeared?
New rules.
New rules.
2020.
2B and 3. The petitioner is not here. No, my lord. Last occasion, Lordship heard this matter, and the last occasion he has also requested to satisfy my lord. Your Lordship has asked how it violates Article 14. There is no representation on behalf of the petitioner. So stop. The order sheet indicates that the petitioner has maintained a casual approach in pursuing this matter, as on previous occasions also. On 27/2023 and 8/8/2023, there was no representation. First off, this application is accordingly dismissed for default.
Item number 3. May I please, your lordship? That is the contempt matter, my lord. 2 years already, my lord, elapsed. The pension matter, the opposite party not complied the order, my lords. In the meantime, my lord.
Where is the order?
My lord, order page 11, my lord. In the meantime, my SLP also dismissed.
Just a minute, where is the order?
Page 11, my content.
Annexure 1.
Yes, my lord.
Where is the operative part?
Operative part, my lord. I am reading, my lord. Opposite page 19, my lord. Para 18. As regards the arrears of the pensions, considering that the petitioner approached the authorities with a request only in July 2009, the arrears of pensions would be payable from 1st July 2009 onwards, and the arrears shall be paid within a period of 8 weeks from today. The current pension will be payable hereafter as and when it is due. If there is any delay in carrying out the above direction, the petition.
My lord, already sanctioned, my lord, 27,33,034 rupees against the petitioner, my lord. So it is pending before financial implication before financial department, my lord. That is the safety department. I have filed it.
File that. But that's not enough. You will have to implement the order. And we shall not dispose of the contempt application till either you comply with the order or you are punished. So these are only 2 circumstances.
My lord, 2 is time required, my lord. That is necessary instruction.
Learned counsel representing the contemners has submitted that he intends to file an affidavit to demonstrate that this court's order violation of which has been complained of in the present contempt application has been substantially complied with, and the matter is presently lying with
Finance department.
the
For concurrence.
lying at before the appropriate authority under the finance department, Government of India. So stop. List this matter on 4 weeks for the contemners to inform full compliance of this court's order dated. What is the date?
Order pass order date 4/3/2022.
4/3/2022, failing which the court shall have no other option but to proceed against the contemners by initiating contempt proceeding against them. Yes.
Item number 4.
Please, Your Worship, my lord. When the virus of section 12 of the Orissa value-added tax is under challenge, my lords, the legislative competency of the state legislatures is under challenge, my lords. It's opposed to entry 54 of the list 2 of the 7 schedule,
Let us have the book.
my lord. I have quoted the provisions in my body of the petition, my lords. I have also annexed my this number of cases pending before this honorable court challenging the same virus of 12, page 76, my lords. And notice has been issued, entry matter has been passed, and pleadings have been completed, my lords.
Pardon, my lord, Lordship,
Page 76.
Prior to my learned senior go into the merit of the case, I am raising the preliminary objection to the maintainability of the writ petition. Lordship, on the same ground, petitioner has earlier filed one writ petition. Lordship, kindly see the order at page 56.
Mr. Counsel, he is challenging the virus of a provision.
Lordship, earlier the petitioner has also challenged the virus of the said provision.
Then what happened?
Lordship, page 57.
He withdrew it to file appeal.
Yes,
He withdrew to file appeal.
To file appeal. Now the appeal is pending, Lordship.
Pending appeal, again he has come up.
Again, yes.
Because in the appeal matters, virus cannot be challenged, my lords. Only I have challenged the assessment order.
Once you have challenged virus,
Yes.
challenging the assessment order,
Lordship has permitted me to
then permitted to file appeal,
appeal, my lords.
appeal. So
But
you filed appeal.
Keeping
against the
question of law
assessment
open,
order.
my lords, for me. Lordship has said so in the order, my lords.
Where is
Lordship,
that?
yes, in the withdrawal order, Lordship has said so. That is also there in the order sheet. I have annexed, my lords. Page 55, my lords.
Hmm.
Because the question, others writs are pending, my lords. The question of law is already pending before the almost all various cases, my lords.
You place
By that time, some
what is the order at page 58?
58, my lords. Let's look, my lords. Learned Counsel for the petitioner seeks leave to withdraw the writ petitions with the liberty to challenge the impugned assessment order, my lord, by way of an appeal. If such an appeal is filed not later than 1st February 2022, accompanied by an application for condemnation of delay, explaining the delay on account of pendency of the writ petition, it will be considered on its own merit by the appellate authority. Full stop.
Just
The court clarifies that it has not expressed any view in the matter. So it's already pending. My petition also pending, my lords. Among that same company, my lords. That is pending. Notice has been issued. Entry matter has been passed. Vital question of law and constitutional validity. The appellate authority.
so we don't have any right to be heard. We don't have any right to be heard.
My-
You had filed this writ petition,
Yes, my lord.
349,
Yes, my lord.
challenging the virus of the act.
Yes, my lord.
Thereafter, you withdrew
Yes,
with a liberty to prefer appeal.
my lord.
You preferred appeal.
Yes.
Again, you have challenged.
I raised the question of virus there, my lord. But virus cannot be decided by the appellate authority, my lords. And already the main vital question is pending before your lordship, my lords. And that has been withdrawn to challenge the assessment order, my lords. Not the virus. Virus cannot be challenged there. That's why, my lords, I have given in last line that we are not expressed any opinion on the merit of the case, my lords, because merit is already pending, lying with my lord in other petitions, my lords.
The petitioner in the present writ application has questioned the constitutional validity of Section 12 of Odisha Value Added Tax Act 2004, bracketed OVAT. Full stop. it transpires from the records that challenging the virus of the same provision, the petitioner had earlier approached this court by filing writ petition giving rise to WPC number 349 of 2024. Stop. He, however, withdrew the writ application with a liberty to challenge the impugned assessment order by way of appeal. Stop. It is an admitted fact that the petitioner has filed an appeal
Yes,
against the assessment order. Stop. It has, however, again filed the present writ application questioning the virus of the same provision which was challenged by it in WPC number 349 of 2014, which was withdrawn. Stop. Learned counsel appearing on behalf of the petitioner submits that it is evident from this court's order dated 7/12/2021, passed in WPC number 349 of 2014, that while dismissing the writ application as withdrawn, the court had not expressed any view in the said matter. Stop. In such circumstance, he submits that the petitioner has the liberty to question the validity of the said provision by filing the present writ application. Stop. He further submits that several writ applications are pending in which the question of
valid.
constitutional validity of so and so
Page 76 I mentioned.
is under challenge. Stop. In the court's opinion, the filing of present writ application is an abuse of the process of the court in the facts and circumstances. Stop. It is accordingly dismissed. How much cost?
And so page
With a
76.
cost, how much cost? With a cost of rupees 10,000 to be deposited by the petitioner in the account of the Odisha High Court Legal Service Committee within 1 month from today. Yes.
That's in other connected matters, the writ petition, number of the writ petition is different. That's
We will see.
We are 24 and 5 or same. Same company.
Same company.
Same
Well,
company.
so in that case also 10,000. In both the
My
cases.
only concern, my lords, page 76, other matters are pending, not mentioned, because this matter will go to Supreme Court, my lords, ultimately. Constitutional validity is there. Other, my humble prayer, my lords, so page 76, I have given all the writ petitions in which validity of the same virus of the same provision is under challenge, and that is pending for your lordship, including one of my petition, my lords, in which notice has been issued, that I mentioned only.
In this case also you had earlier come.
Yes, yes.
WPC 1441,
Yes,
same thing,
yes, ma'am.
same.
Yes.
Very good, 10,000.
page 57 is the order.
My lord,
Item number 5.
I pray my case is dismissed for default.
Which one?
Item number 2.
What are you doing?
My lord, with due respect, on the way, I was blocked too.
So,
Mr. Ma-
Mister, on 2 days you did not appear.
My lord,
On the 3rd day, you could not convince. On the 4th day, you did not appear. Now you are coming.
sorry.
This is not the way.
Previous day I was.
And we don't find any merit. Yes, the brother is right that this is not the way. You could have mentioned after the at the time of recess. This is not proper. File a restoration application, we will see.
Item number 5.
Challenge in this matter is the advertisement policy on welfare scheme by using the party symbol once in various public places by the government of Odisha in various welfare scheme. And the advertisement was published in various Odia leading newspapers in Odisha, in TV channels, flying buses, social media platform.
This is PIL.
This is PIL. Lord.
Who are you?
My lord, I am a citizen as well as a functionary of the General Secretary of the BJP party. In this regard, my lord, a representation was submitted to the Election Commission of India on 10th of November. But after passing of 2 months' time, since no action has been taken by the Election Commission, thereafter,
Who are you?
my lord, I am citizen of India as well as a General Secretary of Bharatiya Janata Party, BJP.
Are you doing politics in the courtroom?
No, I'm not doing, my lord. In fact, I represent, my lord, this
You
is
may
a,
represent, go before the election commission.
for Election Commission, I submitted representation, my lord.
That
No
will be
action has been taken, my lord. After passing of 2 months' time, I approached Delhi High Court, my lord. Delhi High Court, since Delhi High Court has no complete jurisdiction, my lord. As such, the Honorable Delhi High Court advised me to approach this Honorable Court. After that, this petition has been filed. This was
Do you have the advisory issued by the Delhi High Court?
No, not advisory.
Huh?
No advisory, my lord.
My lord, may I say something?
You do whatever you want. Don't do these things in
Lots
the
of
court.
public money has been wasted, my lord, by this, my lord. My lord, may I kindly see simply.
Just a minute. Yes,
I'm
the
sorry.
Advocate General is on leg.
I'm
He
sorry.
wants to address.
My lord,
Page
this is-
111 is the Delhi High Court order,
Your lordship is
right?
right. My lord, but
Page
that's not
110.
everything.
Complete jurisdiction is
That's
here. my lord.
not everything, my lord. If your lordships kindly sees, he has made a representation before the election commission. And the election commission, my lord, on 28th February 2024, has written a letter to the state government, which has been replied. So therefore, in a way, this has become infructuous.
No, my lord, reply has not been made.
Just a minute, making a statement
Absolutely.
at the bar. Otherwise, you argue on maintainability.
My lord,
Don't
second
do
of
it in
March,
court.
time was given by the election commission by 5 PM. They have to submit representation, my lord. Till date, no representation has been submitted, my lord. And they are consuming time, my lord, by the way. And even there is a audit objection of 376 crores, my lord. Audit objection also I have filed here, my lord. On advertisement policy. In large scale, my lord, the symbol has been used in order to image makeover for the purpose of general election, my lord. Lots of public money has been wasted, my lord. So, my lord, may kindly see the advertisement, my lords, made. It start from newspaper, my lord. Kindly have a look, page 52 for a moment, my lords. In various English as well as Odia newspaper, my lord. Page 52, my lord, for a moment. Symbol is there, my lord, and all are welfare schemes with the photographs of the Honorable Chief Minister and various welfare schemes in various government offices as well as in public places, my lord. Thereafter, my lord,
So since
In
when
various-
it was being done?
please, my lord.
Since when that was being done?
Since 10th of October, my lord, is started. And audit objection is prior to that.
No, the advertisement for
Using the symbol.
political purposes was being done since when?
Since 10th of October, symbol has been used in welfare schemes advertisement, my lord. And after that, it is in newspaper, front pages of the various newspaper has been booked till the general election, my lord.
All right. So what should we do? We will have to lay down law.
My lord, may admit this petition, my lord.
Admit.
Admit this and let them file a reply, my lord, in regard
No,
to the.
ultimate. If they accept whatever has been asserted in your writ petition, then what order should the court issue in public
Kindly
interest?
see, my lord, what is the power of the election commission, my lord, what the election commission can do. Even my
Let the
lord,
election commission do.
my lord, code of conduct has been,
We are again warning you. Please don't allow politics to enter into the courtroom.
but I am not doing,
All right.
even my client
This
is
is
not
what you
doing
are doing.
politics, my lord. Say loss of public money, my lord, so that being a concerned citizen,
When did you file this writ application? When did you go to Delhi High Court?
Delhi High Court, my lord, may I kindly see the order sheet is there. 12th of January 2024, my lord.
Very good. And why didn't you go in 2023?
23 symbol was not used, my lord. It is only in during
Then go
October, my
before
lord.
the election commission.
Symbol was used, my lord.
Election commission.
But then election commission may be directed, my lord.
Sorry.
My lord, kindly direct the election commission. The election commission otherwise take
Petitioner.
action, my lord, and directed them to
Sorry.
submit a reply, my lord.
The petitioner has filed the present writ application in the nature of public interest litigation seeking just seeking a direction restricting Bihar Janata Dal bracketed BJD from use of public money in advertisement of various state government welfare schemes by using its party symbol. Full stop. The petitioner claims to be a resident of Bhubaneswar, a resident of Bhubaneswar, and a public spirited person. Full stop. Learned counsel for the petitioner has submitted that the petitioner is BJP leader.
General Secretary of the BJP, but this petition has been filed at the in the capacity as a citizen of India.
That though the petitioner is General Secretary of
BJP.
But your fact is not correct. Your Vakalatama, have you seen? The Vakalatama you have executed in your favor. Have you seen? In what capacity he has given you the Vakalat?
Not seen one.
Of Bharatiya Janata Party.
Even in, I'm sorry, my lord.
He has filed.
Even in the PDS bag, my lord, the rice distributed to the poor people, my lord. The symbol is there, my lord. Even today it is.
Present writ application in his individual capacity and not in his capacity as leader or as a leader of Bharatiya Janata Party. Stop. Next. After having perused the contents of the writ petition and the timing which when it has been filed, comma, just before few. When did you file it?
This petition has been filed before the Honorable Court on 22nd January, my lord.
This writ petition.
Yes, sir. 10th November was the date for representation, my lord. After 2 months, my lord.
Filed before
22nd
the
January.
elections came to be announced, comma, lacks bona fide. The writ application is accordingly dismissed. The petitioner shall, however, be at liberty to raise the issue before the election commission if the situation
This
so warrants.
already has been raised, my lord. My lord may dispose of it, my lord.
Writ petition, if not already raised before the election commission.
Item number 6.
Petitioner challenges the construction of A&M sub-center on a gochar land in Murja Bhutka instead of.
What do you want?
My lord, stop the construction of building on a gochar land in Bhutka instead of the village where A&M is functioning since 1990. That is functioning. Tender finalized, annexure 2, page 14, tender finalized for construction in Border Rampe, where the A&M center is functioning. Serial number 6, constructions of sub-center building at Border Rampe. Here, the sub-center building is functioning, but without the knowledge of the people. Now, the construction is being started in.
So you are resident of which place?
I'm resident of Border Rampe.
Huh?
Border Rampe. Border Rampe. They are constructing in Mauja Bhutka, where already an Ayurvedic dispensary is functioning. This is the primary health center. Sub-centers are primary health centers. They are just addressing the immunity and child care, maternity, all these things. And that is since 90 that center is functioning. But building functioning in Border Rampe, but a building will be constructed in Bhutka, already on a gochar land. Page 17, plus after technical sanction and administrative approval, construction of building tender was held. Serial number 6, construction center building at Border Rampe. This has also got administrative approval and technical sanction.
These are executive functions. We don't interfere in such matters.
There is a function. Sub-center building is there at Border Rampe. How building will be constructed?
We don't run the government. We decide the rights. What right? They are the best persons to decide where should a sub-center be located or should not be located.
There is already Ayurvedic hospital.
Where?
Already, even in Bhutka.
So what is the distance between Bhotka and Badarampi? What is the distance between Bhotka and Badarampi?
Badarampi, it will be 2 kilometers around.
So hardly 2 kilometers. Then what
2 kilometers. Will kindly see.
Yeah. Huh?
Already functioning in one place.
The present has filed the present writ application in the nature of public interest litigation, questioning the decision of the respondents of the opposite parties to construct sub-center building at Bhotka instead of Badarampi under which district?
Jajpur district.
Jajpur. Under the district of
Jajpur district.
Jajpur.
District Rasulpur Tahsil.
District?
District Jajpur. Tahsil Rasulpur.
Stop. It is the petitioner's case that for political considerations, the said sub-center is being constructed on a gochar land in Mauja Bhutka. Stop. Next, it is, in the court's opinion, it is purely an executive function as to where what is sub-center?
Sub-center.
Sub-center of what?
Public health center. Structure of a public health.
Where an A&M,
Branch of public health center and community.
as to where an A&M sub-center should be located. First off, it would not be proper for this court exercising power of judicial review under Article 226 of the Constitution of India to substitute its own opinion in place of the decision of the government and its authorities in such matters. Stop. We do not find any merit in this public interest litigation, which is dismissed accordingly.
Item number 7.
Pardon, my lord. Pardon, my lord. My lord, I have given a representation on our annexure 5 to the collector. Let that be considered.
Sorry.
Item 7.
May I please have? Here, my lord, the petitioner has challenged the very procedure of selection of alerting of the petrol outlet of HPCL, my lord. The advertisement is at page 21, my lord, the relevant page. The person, so far the petitioner is concerned, is a ex-military man and who is also being alerted with that BPCL outlet, being a service provider since 2021. And while he was continuing as such, this advertisement was floated under Annexure 2, wherein certain conditions and selection of the criteria has been provided in page 21. Without adhering to the same, the opposite party number 2 and 3 have ignored the application of the petitioner and alerted in favor of OP number 4, even though it has not yet been executed. Because my tenure is going to be completed in the month of April 2024. As per the brochure, certain marks is to be awarded keeping in view my eligibility. Though I have fulfilled all the eligibility.
No, who are you? Are you running presently?
I am running, my lord, since 2000 from COVID, my lord. My tenure will be completed in the month of April 2024.
Then what right do you have?
My lord,
What right do you have after 2024?
after April, my lord, in fact.
You don't have any right.
But I have all the way qualified so far this brochure and guideline is concerned. And I have appeared in the interview. Though I have secured better marks than that of the opposite party who is going to be selected.
How
But-
do you know that he is going to be?
My lord, over phone, because I have sent
Over
the.
phone?
My lord,
Over phone, you got the information.
over phone, my lord. They have not yet issued, because kind have a glance to
This is
7.1.
premature. Come after the selection is finalized.
My lord, they have not communicating me also. Even to that effect,
They may communicate to him, the other side.
I might have, because in
So
phone,
you keep a watch.
because there is a provision, my lord, and my humble submission at page 25. How the declaration of the result will be
All
there.
right, let the result be declared first.
They are not declaring, but over phone. My lord.
Phone, we cannot quash the phone conversation. Phone conversation,
And
we cannot quash.
my representation is also pending with them.
Representation will not do.
May I be permitted to appear or
This is
represent?
premature. If you want an order, we will pass an order.
They have not yet declared.
What do you want?
Then I will wait for this.
Learned counsel for the petitioner, after some argument, seeks permission to withdraw this writ application with a liberty to approach appropriate forum, including this court, once the selection of service provider
Page special.
for corporation owned and corporation operated retail outlet bracketed COCO is complete with the publication of result. Stop. This application is accordingly dismissed as withdrawn with the liberty as shown.
Miss Miller disposed of
Disposed of. Sure.
diploma.
Item number 8.
Yes.
May Lordship, my lord, this is the contempt petition, my lord.
Yes. I thought you are going to say that it has been complied with.
No, till today, no complaint, my lord.
Yes.
Because I will obtain instruction, Lord, so only 2 weeks time also granted because
All right. 2 weeks.
Complies.
Item number
We
9.
need to inform this court as regards compliance of this court's order, violation of which has been complained in the present contempt application.
May I please? my lord?
Item 9.
Well, this is the second contempt, my lord. The first contempt, which is the first order, which is passed on 14th October 2029. Now, the first contempt, my lord, the order was passed on 11th September 2023, my lord. Now, this is the second contempt, my lord. And against the collector, Sambalpur, my lord, the then collector.
Yes.
so there's the direction to dispose the representation. I'll find out, Lord, sir. You also call it next week only. I can find it out, Lord, so that where he says that he had executed some work in 2019, and in that regard, for payment of the dues, he had filed a representation. Lordships were pleased to dispose of the writ application 14/10/2019, and the contempt order was passed on 11/9. So I will find out, Lord, only which time I can get the
2
confirmation.
weeks. Who has to pass the order?
Right.
Who has to dispose of the representation?
Collector, Lord, so.
Collector. Let's this case on. It appears to be. This is case on 4 weeks. So stop. 4 weeks so as to enable learned counsel representing the contemners to seek instruction as to whether this court's order dated 14/10/2019 has been complied with or not. We'll stop. If on the next date, if by the next date, the petitioner's representation submitted in the light of this court's order dated 14/10/2019 is not disposed of, who is the collector?
So my
The
friend,
then collector, my lord, is Subham Saxena.
And two? Who is two? The
District Social Welfare Officer, I think your lordship should.
opposite party number 1 shall be required to be present in court for this court to frame charge of contempt against him. Charge of contempt of court against him. Yes.
Item number 10.
You were not present when the order was passed, do you know?
Well.
When that order was passed
Well.
for disposal of your representation, you were not present. So that order was passed in your absence. And what was the order? File a representation that shall be disposed of.
No, my lord. Actually, my lord, at that time, it was a law strike, my lord.
Huh?
It was advocate strike, my lord. A law strike on those days, my lord. So I was constant to appear before the
All
court, my lord. in 2019, my lord.
Item 10.
May it please your lordship. The learned single judge has directed for grant of promotion pending completion of vigilance proceedings. The order starts at page 12. And it was passed on the very first day without issuing notice, without service of copy. In an identical matter, same appellant, identically worded order, your lordships have already passed, allowed.
Have you seen the note? Have you seen the note?
My lord.
He is appearing for
Yes,
respondent
ma'am.
number 1.
Yes, ma'am. Lordship, I have filed a IA application 943 of 2024. This appeal has been preferred against the impugned order, which is under annexure 1, your lordships. And the learned single judge has only, my lord, given the direction to carry out the government order, because the petitioner was joined, my lord, the present respondent.
That is not the question. His only grievance is
My lord.
that whatever order was to be passed in his presence. There he appears to be correct.
Only thing is that, yes, your lordship, but here in this case, in other cases, they are showing, my lord. In this case, your lordship.
Is there something in that?
Lordship may see their writ appeal, my lord, at page number 9, the ground E, my lord. Only ground of challenge of this writ application, the writ appeal is that I was entitled to get the promotion since 30/12/2022, and the learned single judge has allowed the application to carry out the order since 31/1/2021. This is the only
This
grievance.
is the order which we intend to pass.
Great.
Have you seen that order?
Yes, my lord, your lordship has sent the matter to the single. Only I proposed, my lord.
There was no interim order?
There was
Yes, interim order was there. Your lordship has to vacate.
Interim order, where is the question of vacating it? It stands. Last sentence and you are not required to. Paragraph 6. Is that required? Interim order was in favor of the. Application. Stand disposed of.
Only one thing I would like to draw your attention. Your lordship, I direct to take up this matter before the single judge, because it may be listed, my lord. My lord. Only one line order, your lordship.
Mr. Counsel, you should know what the proposed order should be in writ appeal. To what extent we can direct? We are in writ appeal.
Yes.
Not as appellate authorities against the learned single judge.
Now, just think of a situation and then you can understand it better. That had there been a bench presided over by Honorable Mr. Justice Raman, a division bench, and the appeal before him, and the Chief Justice, the single judge, then what would happen in this situation? Whether that bench would have asked the Chief Justice to decide. So there is no difference between the Chief Justice and a judge. All of them are equal. All right.
Only in view of this appeal, my lord, pending, he was divided to get the promotion since 2020.
You should not have.
Still, you could not get the indication. Still,
Your lordship.
It's unfortunate, sir. Should know what to be presented before the court. You are arguing in a writ appeal, not ordinary appeal.
Item number 11.
Well, delay of 101 days, my friend has filed objection. What I propose with objection, my lord's acceptance and also his. There's my lords have already kept similar matters to 27/3/24. So my lord may kindly condone the delay
Yes,
and be posted there. So my lord will be deciding on merit.
Yes, ma'am. 27th, ma'am.
For the reason stated in
This is the
IE number,
order of the,
the
along with that, ma'am, this matter.
delay stands condoned. Delay in filing the present appeal stands condoned. List this matter with WA number 170 of
24 on 27th,
on 27
March.
3 2020.
Yes, ma'am. Obliged.
Item number 13.
Yeah, these numbers may kindly be pardoned. Item number 12. Minus fixed it at 2 o'clock. Fixed it at 2 o'clock minus. Item number 12.
It's fixed at 2.
2 minutes. With due humility, my lords, I'm appearing for the opposite part number 5. I'm not appearing, means my senior.
Make a mention at 2. We'll see. Let others also come.
Item 13.
So you have come again and we are not prepared again. Just go through the dictate order. I am okay. Next Monday. Tuesday. 27.
Obliged, Judge.
Item 14.
Item number 14 on behalf of Mr. Enleka, my lords, no instruction. My lords, no instruction.
So we're dismissing it.
My lords. Lordship may dispose of.
This the present rate application which is pending 6,000. So, the application stands for the law.
Item number 15.
And both the matters. Item 14, both the matters.
14 both.
Unless there is a connected matter. Also.
Yes.
Maybe.
Right. May I please, Your Lordship?
Yes.
Page 124, Annexure 3. The order of Honorable Single Judge is under challenge here.
Yes.
Well, I'll draw my lord's notice to paragraph operative person, my lord. Para 8, my lord. Para 8, 9, 10. Lordship, page 136, para 10.
Yes.
In the backdrop of the aforesaid factual exposition and after having restored my anxious consideration to the rivalized submissions, the cases of the petitioner deserves consideration for regularization in view of the following facts, reason, and judicial pronouncement.
Admittedly, all the petitioners in portions of the advertisement and after undergoing the process of selection were appointed as executive assistant or contractual basis since 2012. In the meantime, they have completed more than 8 years of contractual service against the post of executive assistant, which has been subsequently re-designated as junior assistant on recommendation of the syndicate subcommittee in the year 2013. Government of Odisha by notification dated 16th January 2004 has published a contractual rule 2013 where on completion of 6 years of contractual service one will be eligible for regulation in service. Since the petitioners have completed the requisite period of service, their service ought to have been regularized by the university in the light of the notification of the GA Department, Government of Odisha. Much has been argued on behalf of the state that the initial appointment of the was against a non
Matter.
This is matter regarding the regulation of service.
What happened? What will be the
The direction to regularize them in accordance with the ratio decided in the case of Uma Devi. And I draw my, he is not covered by the decision of the Honorable Apex Court in the case of Uma Devi. I'll draw my lord's notice 2 dates.
Yeah.
First, he was appointed on contractual basis.
But subsequent decision is also followed.
He does not.
Narendra Tiwari.
Yes, he does not fall within the ambit and scope of those judgments. 2 dates, my lord, important, my lord. He was appointed on contractual basis. On 3/6/2013.
Yeah.
Sorry, on 35/2012.
Yeah.
You'll also see the judgment 120 for the date. Hello, 3/7/2020.
3/7?
2020, the date of the judgment, my lord. Why I am showing 2 dates, my lord? Thereafter, I will come to Uma Devi.
Ten years.
Yes.
You want to show the 10 years?
Yes. Admitted fact on the date of judgment, he has not completed 10 years, which is one of the criteria of Uma Devi.
Now he has completed.
Now, second aspect. In 2014, he approved, my lords, and by virtue of interim order, he is continuing.
No interim order.
No, there is no such
Interim order of stay of the arbiter.
Please.
Yes.
In 2014, when an advertisement was made for regular recruitment, he approached this honorable court.
Yeah.
And the honorable court has stayed that advertisement. So they continued after the stay of that recruitment process, they are allowed to continue by the university. Admitted fact.
Recruitment was stayed.
Admit.
Any interim order to the effect that.
No, because that advertisement for the regular post was stayed. So in order to manage the post, they were allowed to continue because they could not go with the recruitment process.
You have not filed any petition for vacation.
Yes, everything was filed. Finally, it was decided in 2020. And another aspect I'll draw my illustration seen that page 136.
It seems you have filed only counter.
Count.
But,
Illustration page 136. On 3 grounds, Honorable Court has directed for regulation. Illustration 3. Mods has been argued on behalf of the state that initial appointment of the petitioner was against a non-sanctioned post. Therefore, regulation of the petitioner against the non-sanctioned post is not legally permissible. But the letter of the Government of Odisha and the Department of Higher Education dated 8/7/2008, which pertains to the review committee meeting regarding filling of the teaching and non-teaching post in Sambalpur University, indicates that said review committee meeting was being attended by the members of the Higher Education Department, Finance Department, and by a conscious decision, the post of junior assistant was redesignated as executive assistant. However, the advertisement was published and the petitioners appeared in the selection process and were appointed against the post of executive assistant in lieu of junior assistant. Subsequently, in the year 2013, by virtue of the decision of the subcommittee, the post of has been redesignated as junior assistant and the petition have been continuing against the post of junior since 2013. Taking into consideration on interpretation rendered by the against the redesignated post of junior and on perusal of the notification of the state government regarding regulation of contract, it is quite looking that petitioner have rendered more than the requisite period of service against the sanctioned post and vacant post of junior in the state of their claim for regulation. May I draw my lord's notice that review proceeding dated 8/7/2008. Else you can find it from page 116. Page 117. Serial number 13, well. A junior assistant to be filled up by executive assistants having computer proficiency through outsourcing. And the decision was to give them appointment through outsourcing that executive assistants. And LSM is the advertisement. It is page 99. Sorry, my first advertisement was
2014.
No, sorry, my 2011 advertisement is at page 63. Also very important, the first 3 lines. Because the post was contractual. Sorry, ma'am.
Yeah.
Because the post was contractual. So this application was only confined to Sambalpur district only. Married, madam?
Page 5000 consolidated.
The first 4 lines. Yes. Applications in prescribed form are invited from the candidates belonging to the area under the territorial jurisdiction of Sambalpur University. conferring to the following condition, so and so. And the post is executive assistant and post number is 15.
But when we had taken a decision that the work shall be outsourced,
My lord,
then why did you come with this advertisement?
but this is the university. University has done this. The state government has come with the entire dispute between that. State government has never directed to give them regular appointment. State government has directed to fill up 21 posts of executive assistant through outsourcing basis. Instead of giving them appointment through outsourcing basis, they appointed on contractual basis and they consolidated 5,000. Now, thereafter they took a decision that will be paid from their fund, pay 66. The university took a decision page 66. Last personal result. Number of computer knowing assistants be appointed at the first phase of the consolidated remuneration per month from the own source of university temporary pending approval of the same by the government. It is further the result of thereafter my government
Result. Page
66.
page 66. Last portion. Just about the signature. That resolve.
Yes.
20 number of computer knowing assistants be appointed at the first phase on consolidated remuneration of rupees 5,000 per month from the own source of the university template pending approval of the same by the government. It is further that the result of the recruitment to be published following work so and so. And that are the result of that advertisement. Then my lord,
No, what was the post?
my lord, executive assistant, my lord.
This is not the,
This is not the junior assistant. The advertisement is the executive assistant.
This resolution is of the university.
Yes, university. Then my lord, also may turn to page 78.
the mission is dated.
This is the resolution dated my 18/5/2012. 18/5, my lord. 2012.
What is the date of advertisement?
Date of advertisement is my lord 26th March 2011. My lord.
Yes, can be before the resolution.
Yes, ma'am. They issued the advertisement earlier. They took the decision subsequently. And this was the advertisement of 2011. They conducted the recruitment, university conducted.
Your main submission is that posts which were advertised were not sanctioned.
Yes. Yes, ma'am.
Government wanted it to be outsourced. Government
Yes.
wanted it to be outsourced.
Through outsourcing at that point of
Through
time.
outsource.
Through outsourcing. And I'll draw again another notification, page 78.
And the posts are also different.
Posts are different. In that university, there is no post of executive. The post is junior assistant. There was no post of executive assistant. So in that meeting, they took a decision to fill up those posts through outsourcing basis. The post is junior assistant. You'll also see page 78.
Executive assistant, post of executive assistant, which was advertised on 28th of March was never sanctioned.
Yes, madam. There is no post of executive assistant under the university.
Yes.
Your Lordship, I say page 78.
No, but then why are you referring to this page 66? What is the relevance?
Page, because that was relevant. Advertisement was made in the year 2011. Thereafter, they did not make appointment because there who had to pay with the resolution of 2008. They have to be paid for, they have to be engaged for outsourcing agency. But as the university decided to engage them on contractual basis, so in 2012, university also passed the resolution to give them on contractual from their own fund. So that was the relevant type. Government has never permitted to give them appointment either on contractual basis or on a regular basis. Only government has taken a decision to appoint them on outsourcing basis to the executive assistants.
So what is the provision for sanction of a post in the university?
Yes, government sanctioned that I am showing that page 78.
63.
Posts are sanctioned. You'll also page 78. I am directed to invite a reference to a letter number 11020 dated 22/12/2012 and number 18 dated 11/2/2013 on the subject cited above, and to say that the government have been pleased to accord permission to fill up the non-teaching post lying vacant against the sanction post in Sambalpur as mentioned below by following the prescribed procedure. Lordship, page 79.
Yes.
Serial number 14, mail.
Yes.
Post is junior assistant. Number is 11.
Yes.
Government permitted the university to fill up these posts following the due procedure. The procedure is laid down under Odisha University Recruitment and Promotion of Non-Teaching Employee Rules 1991. Thereafter, the advertisement was made. Page 99.
No, let us be clear on this.
Well,
Whether on the basis of this advertisement of March 2011, they were appointed.
Yes, ma'am. On the basis of March 2011, they were appointed as executive assistant.
In 2012.
2012.
So what is the relevance of this, all developments which had taken place subsequent to their appointment?
Well,
What is the relevance of the developments which had taken place after their appointment for the purpose of this case?
I could not follow, my lord.
What is the relevance of such events which took place after their appointment in 2012?
Yes, ma'am.
That was based on 2011 advertisement.
2011 advertisement.
2011 advertisement, certain posts were advertised.
Executive assistant.
According to you, those posts were not sanctioned.
Yes, my lord.
And that is the only ground which you are taking.
Yes, my lord.
Then why are you referring to subsequent resolutions or development?
Why subsequently, my lord, your lordship asked me if they have taken a decision for outsourcing, why they were appointed on contractual basis. So I took my lordship that resolution, they passed a resolution, they will be appointed on contractual basis and they will bear their cost. And after this resolution, they were appointed on 35/2012 on the basis of their resolution. So government, I have shown my lords that government have permitted to fill up 11 posts in 2013. Your lordship has seen that page 78.
How again I am taking the same question. How is that relevant when they were already appointed?
They are appointed as executive assistant.
Here, government decided to fill up the post of junior assistant. That I am sorry, my lord, I could not convince my lord.
Oh, they were appointed as
Executive assistant,
executive assistants.
my lord.
This is your case that no post of executive assistant is sanctioned.
Yes, ma'am.
This is the only point which you are.
Yes, ma'am. That is the only point.
So they have to demonstrate that the post was sanctioned.
My lord.
All right.
My lord.
So this is the only. This
Yes.
what
Another aspect I will drop. Your lordship has seen that advertised, 15 posts were advertised, 30% were appointed.
it is different.
But, so they 30% are claiming regularization. And which are the subject matter of challenge before my lords? Page 99. Sorry, my lord, before the honorable single judge, page 99.
In the writ petition,
Yes, my lord, in my writ appeal, my lord.
writ appeal.
My lord.
Advertisement dated 4th
4/9,
September.
2014.
Junior assistant posts, 11 junior assistant
Yes.
posts were advertised.
Yes.
But online applications are invited from eligible candidates of the area under the jurisdiction of Sambalpur University for appointment to the following non-teaching post. The online app is available at the university so and so. Junior assistant, serial number 1. Junior assistant, 11 vacancies. That which government has permitted to fill up 11 vacancies. So this was the subject matter of challenge in the writ petition. They challenged it on the ground that since they were appointed in 2012 and against the post of executive assistant and subsequently university has redesignated as junior assistant, so they should be regularized without going for a further recruitment.
Yes.
And this is the case. Our case is that they were never appointed against the post of junior assistant, and they were appointed against the post of executive assistant, which is a non-sanctioned post, and they are not covered under that Umadevi case. And the government has never decided to appoint them on regular basis, and only the executive assistant posts are to be filled up through outsourcing basis.
That's all.
That's all.
Yes, sir.
Yes, sir. My lords, I would like to pray my lords to have a look to page 60.
No, but, can you show us whether those posts were ever sanctioned or not?
Yes, my lord. Page 60. This was the hyper committee of the state government. Your lordship can come to page 62. No doubt in serial number 33, my lord, post of junior assistants are mentioned. But it was decided by the state government that to fill up the executive assistant having computer proficiency through outsourcing basis. My lord, this is against the junior assistant post because they wanted that the junior assistant post is to be filled up by process of the executive assistant. What they wanted, my lord, I satisfy my lords. Series and again, the university has brought to the notice, even to the notice of the Honorable Chancellor, about the problem they're facing because of the non-availability of the post of junior assistant in the university. And in 2008.
No, let us see. You are referring to page 60. What is there in page 60?
Yes, ma'am. I'm referring to page 60. This is the proceeding of the review meeting held under the chairmanship of Sri, etc., Chief Secretary, PM at the second floor conference hall to steps taken with regard to the filling of the vacancies of teaching and non-teaching staff of Sambalpur University. This was the basis for my lord. There, my lord, the specific stand was, it was attended by the Chief Secretary,
No, but where is the post of executive assistant sanction?
Yes, my lord.
Where is that?
My lord, they said that in place of the junior assistant, they will be appointing persons in the grade of junior, the post of executive assistant.
Where is that?
This is, my lord, the serial number 33 at page 62. Number of posts, my lord, required is 23.
Serial number 13. Serial number 13.
Sir, 33.
13, sir. There is no 33. It is 13.
I'm sorry, yeah, that is 1 3. I'm
One
sorry,
three.
1 3. I'm extremely sorry because that print of that is so let me referring to my own
Junior assistant 23 posts.
Yes, that will be 1 3, my lord. I'm extremely sorry.
What they are arguing is against you.
Yeah, my lord, I'm sorry because the print they have given that was not visible.
No, counsel, this is against you.
My lord, junior assistant is the post. Your lordship can have come to the table that was in page 20, that 61 probably. I'm referring to, no, table that next. Page 61. Number of posts, number of proposed to be filled up, number decided to be filled up, procedure of filling of the post. This is the tabulation, my lord, that was decided by the state government. Number of posts, my lords, at next page, my lord, 23. They wanted to fill up the post 23, but junior assistant post, they wanted to fill up as executive assistant. That is the decision they have taken. Procedure to fill up post is by way of appointing in the post of junior assistant. They will appoint in the post of executive assistant. And this was also passed by the university bylaws. University is the appointing authority. University has taken a decision in their own resolution to convert the post of junior assistant to that of the executive assistant. And we have been continuing for the last 12 years, my lords, without the protection of any court or protection of any interim order. This would, my lord, with my due respect, my lord, this would indicate the post of junior assistant, 23 number post, they wanted to fill up by way of appointing persons as executive assistant. And accordingly, my lord, the advertisement was issued. And it should get the return.
So this can be your submission.
My lord.
This can be your submission that 23 posts of junior assistants were sanctioned. All right. Against those posts, or those posts were to be filled up by the
executive assistant. Yes, ma'am.
Already, but through outsourcing.
Through outsourcing contractual basis, my lords.
On contractual basis.
Yes, my lords. Now, what the university did
remains that the posts were sanctioned. It is not that the posts were not sanctioned.
Were not there, my lord. Before 2008, all the posts of junior assistants were remaining vacant. Almost all the posts, my lord, if I
All right.
place one or two.
Whether you were holding any post of executive assistant at any point of time prior to the advertisement.
Minus my learned friend university. I am for the persons, those who have been declared to be regular. I am for the employees.
My executive assistant is a non-existent post. It doesn't exist in the cadre. The only post.
Mr. What we understand from this table that executive assistant posts are outsourced. They are already there, and from amongst them, 23 posts are to be filled up by selecting those persons working
Regularly,
as executive
as per law.
assistants.
Well.
They will be put in the posts of junior assistant.
Well.
That is what we were discussing, but subject to
See, there was
your.
I am bringing the background of the case into this manner.
there was no post of executive assistant
There was no post of executive assistant.
when this meeting was held in 2008.
Madam.
All right.
Executive assistant post was created means they came into concept only when they did not want to appoint junior assistant. By appointing executive assistant contractually, they would continue and continue like that.
It is your unilateral decision by the university.
No, madam, it has been sanctioned by the government. It has been approved by the government.
Where is it?
This resolution was a place, my lord, of 2008. This is the decision taken by the Hyper Committee of the state government. This is the decision taken, my lord, that paragraph 2, the university has submitted the proposal seeking permission from the government.
Where?
That's, my lord, the that is the 28 page are different. No. My lord, the
page 60.
It's 60 we are there at page.
Yes, yes. That read petition of the read petition now. Yes, my lord. That is on page 62. It starts from page 61, my lord.
No, that
Non-teaching post clause 2.
No,
how does it help you?
It can't be, but because 65.
65.
65 is the minutes of meeting of Sambalpur University, 18/5/2012.
65, my lord. That's a resolution of the syndicate of the university.
Yes.
Yes, my lord.
You come to last page of that.
That is, my lord.
66.
Para 63.
66, that paragraph resolved.
Resolved, yes, ma'am. That 20 number of computer knowing assistant be appointed at the first page on consolidated remuneration of rupees 5,000 per month from the own source of the university temporarily pending approval of the same by the government. It is further resolved that the result of the recruitment be published following ORP Act strictly on the basis of conduct, written test and computer skill test.
Meeting is 65. The university unilaterally, they are in the syndicate, they are decided.
The resolution has been resolved pursuant to the observations in para 63 of the same page.
No, but how do you connect this? How do you connect this with the post of junior assistant or executive assistant?
My lords, I'll give 3 dates, my lords.
No, university can only say this. Page 66.
Page 62,
That is why I asked,
Para 63
that is why I asked, is it your unilateral decision
Yes, madam.
pending approval of the government.
pending approval?
Page
But government has never approved. That is what
Government-
he has argued.
Government has,
So
government
this-
was only interested in going for outsourcing, my lord.
Yes. Page
But-
66, last
So in the-
paragraph.
whether in
that is-
whether in the matter of sanction of posts, you
May I
can take
take-
decision contrary to the decision of the state government.
No, I did not contrary to it. Subsequently, they have again given the seal of approval by allowing us to convert the posts from junior executive assistant to junior assistant.
Where is it?
That is the chief secretary decision, meeting of the chief secretary.
Where is that? Till 60.
And the university resolved it, my lord. University resolved to convert it.
The prima facie that is will subject to your submission finally.
Yes, ma'am. Your lordship, to meet the query, I will make a small date chart. Can my lord be given 2 to 3 days time? So that I will be able to meet the point whenever it is called. Because there are so many dates and so many facts, my lord.
All right.
April. Given 2 weeks time, my lord, this can be.
Just a minute. Applying the ratio laid down by the Supreme Court in case of Uma Devi. What is the citation? Uma Devi, 2014, volume 7 SCC 223. 14. Oh, Tiwari.
6 SCC.
2006.
6, no, sorry.
6 4 SCC, no?
Yes.
Page 1. 2006 SC must be 1. Absolutely no. And Narendra
2006.
Kumar, comma, State of Jharkhand versus Kamal Prasad, reported in 2014, volume 7 SCC 223. And Narendra Kumar Tiwari and others versus State of Jharkhand, reported in 2018, volume 8 SCC 2000 SCC 238. Learned single judge by a judgment which is in judgment by judgment and order which are impugned in the present intra-court appeal has directed regularization of the services of the respondents against the post of executive assistant
No, well, against the post of junior assistant.
Junior assistant in Sambalpur University. Sambalpur University, Sambalpur. Full stop. It is the case of the state of Odisha that the Supreme Court's decisions in the aforesaid cases do not apply in case of the respondents, as they were not engaged on contractual basis against sanction posts.
Yes.
It is definite case of the appellant state of Odisha that the respondents were that the post of junior assistant was not sanctioned.
Junior assistant post is a sanctioned post. But the post of executive assistant.
That the post of executive assistant against which the respondents were appointed were not sanctioned.
Yes.
Full stop. Learned senior counsel representing on behalf of the respondents, on the other hand, has submitted that he is in a position to demonstrate that the posts of executive assistants were sanctioned, against which they were appointed on contractual basis. Full stop. He seeks adjournment to satisfy this court on this point by referring to various documents available on record. Full stop. As requested, list this matter on when?
April 1st week, my lord. April 1st week.
You were telling him something.
Pardon, I wanted a little longer time, my friend.
No, you were trying to say something, convey something to him.
I had wanted to object noting of that matter. I wanted to show sanction letter of appointing this executive assistant. In fact, 40 posts of junior assistants were already available, my lord. That thing. And in place of junior assistant, because they were not given the permission to fill the post of junior assistant, actually executive assistants were appointed. But following due procedure of law, all the university appointment procedures had been resorted to, and posts were available as junior assistant. And subsequently, the government, they have decided to convert the junior executive assistant post to junior assistant.
25th January.
To meet your lordship's query, I have to satisfy your lordship as to whether the executive assistant post were filled up with the permission of the government.
On the next date, list this case on so and so only. On the next date, the court will also consider the stand of the state government relying on the Supreme Court's decision in case of University of Delhi versus Delhi University Contract Employees Union, reported in 2021, SCC Online, SC 256.
On 25th January,
this stand was taken.
Yes.
this stand was taken that this,
Yes.
this matter is covered by this. judgment.
2021,
So
16
you also
SCC.
get
Yes.
So you also be ready on that. At 2 p.m. 2 p.m.
Item number 16.
For taking up this matter, may I beg your lordship kind permission on behalf of the Photographers Association, Miller. This matter relates to regulation of the photographers of Sun Temple, Miller. The association itself, which has been established since 1984, has filed an intervention application, Miller. The association is a stakeholder, Miller. The association seeks your lordship, seeks to bring some relevant documents which are not in the file to your lordship kind notice in that.
Sorry.
That will not cover. Intervention application is there. We have filed it.
We will reject that.
That will be included in your lordship, Miller. My only prayer.
We shall.
Already
Yes.
filed it.
No intervention.
My lord, my humble submission is I am in tagged up matters, my lord, that are read petitions, my lord. There, my lord, the challenge is little different, my lord.
No, first of all, let us decide IA, this intervention application. Where is that?
Miller, my intervention application is filed by Mr. IA number Miller 987 of 2024, Miller. It has not been tagged up with the lordship. Read the bill. Copy that only they don't.
No, we are not satisfied. That we will not allow.
I have a right to say.
Just now they are serving the copy. Can you read a bill? May I clarify one second, ma'am? Here is the case. The government of India put a scheme for the photographers in Konark Temple, ma'am. That is a scheme for all the monuments all over India. Here we have granted license to some of the photographers. They have minimum qualification and so they are fulfilling the criteria was fixed in the scheme itself. That came into force in the year 2017 and basing on that selection has been made. Now problem is coming, the crux of the issue is that some of the photographers, admittedly they are working himself as a photographer without any authentic license. And now they are saying that we are getting this photograph license from the state government and tourist department. Tourist department communicate us that because the ASI is the authority to issue the license to the photographers. That they are saying that we have not issued any ID card. Where they got the ID card, what capacity they are coming and acting there as a photographer, it was not known. Now question is coming that whether this basing on this scheme from the government of India to ASI, this photographer will prevail. Or some others, those who have no locus standi or they don't have any capacity to come enter to the Sun Temple, will act it upon. This should be decided by the court.
My humble submission. I have challenged the capping of numbers of the photographers.
Who is for the appellant?
I am for the appellant.
Who is for the appellant?
My lord, no, my lord, I am in the tagged up matters, my lord.
Right.
That's why I am submitting that.
You are also the appellant.
No,
you are also for the appellant.
Yes, my lord. He was not. My humble submission is.
You are also for the appellant.
No, my lord.
Then let the appellant say something first.
My prayer for intervention is there, Miller. You will kindly consider it because I am.
Please allow us to hear.
Wait, please, my lords. My lords, these applicants, my lords, 154 in number, before your lordship, my lords, in appeal. They were photographers in the Konark Temple, my lords, more than 20 years and some, my lords, more than 30 years. All those, my lords, these quantum of time quantums have been recorded in your lordship's order, earlier order. Now, my lords, in 2007, my lords, guidelines were floated. Under that 2007 guidelines, these, my lords, photographers, my lords, they all applied for the license. And they would have qualified under the 2007 guidelines. The applications were kept pending, were not disposed of. And finally, my lords, 2017, a new set of guidelines come. And by the, my lords...
No, these guidelines were issued under which provision?
The, my lords, Ancient Monuments, Architectural Sites and Remains Act 1958. These are statutory guidelines.
Where is that?
My lords.
Let us see the act.
Much. They say it's statutory, but it appears to be some kind of an administrative arrangement. And that was probably the finding of the honorable single judge. This is,
I have annexed that,
What?
that guideline and that rule.
the guidelines.
Guideline is there.
We have also annexed the guidelines.
Really, we want to know under which authority the guidelines were issued.
Rules.
8D.
Section?
8D.
Rule, not section minor. Rule 8D.
Rule aid.
Rule 8. Miller, that is at your lordship flag
Rule
3, Miller, of your lordship flag 3.
Rule.
That
We cannot hear this is how you are.
Rule
We
aid.
cannot hear it. We cannot hear it. Please try to, please make your plan outside the court. This is not the manner in which the cases are argued. Yes, where is the provision?
The
Let's the case on 2 weeks so as to enable and counsel for the parties to prepare on the legal issues so as to effectively address this court.
Item number 17.
My lord, adjourning to some date or?
Yes, after 2 weeks, we will get the dates.
great.
Item 17, they have filed, state has filed an affidavit last week. We want to give a reply to that because additional affidavit is required.
And senior counsel appearing on behalf of the appellant states that copy of an affidavit is filed on behalf of, it has been filed.
Filed at server.
Filed on
Sir,
behalf
copy has been
of-
served.
The state has been served upon the counsel for the appellant recently, which requires consideration. First off, as requested, list this matter on when?
As your lords, please. I think first week of April or second week of April. First week or second week of April. As your lords, which will be convenient to us. First week of
Third of
third April.
Item 18.
In item 18, on 13(3), my lord, I undertook that I will produce the rules. My lord, I have inquired. In fact, at the time of this recruitment, no rule was there. But my lords, admittedly also, there was a statement in the counter that the recruitment has been done in accordance with the rule. So, my lord, I was also informing my lord senior. I will prepare an affidavit in this regard because my lord's pinpointed query was what was the rule. My lord may kindly allow me to file an affidavit in this regard as to what we have followed. I have got the documents with me because it was a committee which took the decision, my lord, and that recruitment was done.
In a way, your counter was flawed.
My lord,
as pointed out by Mr. Misra.
my lord, there was a statement. I will have to also address that in my affidavit, ma'am.
There is page 38 today.
Yes, what do you want?
My lord, may kindly allow me to file an affidavit, explaining the situation as to what exactly we followed while this recruitment was done.
I think the same rule is applicable as per the class through 3 employees of the family, health and family welfare department. You can check out that.
No, normally, we don't allow filing of affidavits in writ appeals, which have to be decided on the basis of pleadings already available on the court. Why further?
There is a, it was clearly the post are being filled up in a transparent manner by following the following recruitment rules of procedure and provisions of law. It is reservation. So, on the other question, he pointed out he is not able to find what is that relevant rules. So he posed a question. So that was actually posed before the managed scene. So now he is not this.
What was the post? What was the post?
Post actually is a vocational
counselor.
Counselor.
So you could not lay your hands on recruitment rules?
No, because
Class 3 employees of family and health and family welfare department will be applicable here. I think that is the rule they had followed, in fact.
As requested on behalf of the estate. How much time?
I'll definitely, my lord, do it within 7 days' time.
2 weeks' time is allowed to carry out this court's order dated. Should we refer to that order?
My lord. 21/1/24 and 13/3/24.
No. Yes.
But the interim order is there.
I am for the respondent. I am for the private respondent of it.
Yes, all right.
Here the order has been passed, the single bench order is in my favor, but I am debarred from enjoying the.
Not in his favor, not in your favor.
Bring out the rules.
But it was against me.
You bring out the rules which are required.
Yes.
You bring out the rules.
That rules of the government.
The order is in your favor, but where is the rules? We want to see
the government of the.
Senior counsel asks for those rules.
My description, that is the.
So if you have the rules, then you can.
No, I have no.
Right.
Item number 19.
19, my lords, remember, my lords have heard it. My lords asked me the most pertinent question, where is the cadre? That para 10 cadre. I was to show, my lords, that the cadre of station officer is different. So he cannot get the grade pay of station officer. So my lord, may kindly take up after lunch. I will serve the copy of affidavit. It is being shown in, man. It's being typed out, it's being shown in. So
tomorrow, let him stop to copy today. Tomorrow.
It is stated by the State Council that filing of an affidavit is underway, a copy of which shall be served upon learned counsel for the respondent in course of the day. Stop. Can we take up tomorrow? Tomorrow? Yes, ma'am.
My lord, shall I keep it to be handed over to my lords, or I will file it in the registry?
File in the registry. Then it will come on next week. File it in the registry, that will be better.
My lord.
1 week.
Item 20, made
My
to
lord,
you.
in this case, I have to file the counter affidavit on behalf of the state. And in respondent number 4 and 9, they have filed 2 counter affidavits. So I have to give a compiled reply to the appellant and these 2 respondents. I pray for some time to file the last chance. I am
In
seeking.
WA 2051,
Yes, ma'am.
Yes, my lord.
the system of filing counter affidavit in writ appeals.
No, in the writ petition, there was no counter. That is.
Writ petition, there was no counter.
4 weeks time may be granted as a last chance.
AGA representing the estate of Orissa submits that he requires time to file a counter affidavit dealing with the facts mentioned in the present writ appeal.
And the counter affidavit
As
filed by respondent number 9.
The counter affidavit filed on behalf of respondent number 9.
9.
Yes.
Lordship may direct the respondent number 9 to file serve a copy to.
I am appearing for opposite number 4. I will also file counter affidavit within that time.
Then he will again to take time to
No,
file
no.
reply to your
He will
counter
have
affidavit.
copy on me.
Yes,
I will deal with it. Lordship may give me some long time so that within that period, every day pleading will be completed. 6 weeks time.
6 weeks. My lord, I am.
That is, we have to reply 2 counter, 3 counter affidavits.
It is 3 times. It is
Oh,
time has been.
But they have filed, given the
Is there
counter
any
affidavit
interim
today.
order?
Yes, my lords. Yes, my lords.
That is against the cancellation, there is interim order. But regarding the penalty and imposition, assessment of the penalty, there is no interim.
In this case, my lord, the appeal was the whole contention whether the.
I will file counter within 4 weeks after the pleadings are completed. Your lordship may hear it within 4 weeks.
Appeal is there to the Supreme Court.
You are for whom?
I am for state environmental impact assessment authority.
Respond number 4.
Respond number 4.
And you?
I am for the respondent number 1, 2, 3. Villagers. The writ appeal.
I'm for the state pollution control.
Respond number 9.
Counter already filed.
Today they have served the copy. Only 4 weeks time, last chance, we will file the comprehensive counter affidavit replying all the appellant and respondent, everyone.
And you are the appellant.
Yes, ma'am.
The parties as the writ appeal, as the writ petition was decided without any counter affidavit.
Yes, ma'am. Yes.
The respondents shall have the liberty to file their counter affidavits within 1 week from today. No further adjournment shall be granted to them for the said purpose.
Some more time maybe.
Some more time maybe.
No, for them.
Oh, them. I'm sorry.
For
2 weeks.
them, other than your
State.
So stop. 4 weeks time is allowed for the state
Yes.
to file a comprehensive counter affidavit dealing with the stand taken in the writ appeal as well as the facts asserted in the counter affidavits filed / to be filed on behalf of other respondents.
Yes, ma'am.
You also may grant 2 weeks. 10 days.
Hey, तो
What is wrong with the?
My lords, here is a writ appeal is maintainable because the writ petition has been dismissed on the ground there is an appellate provision. Whereas, my lord, there are cause, my lord, my contention is, my lords, even though there is an appellate provision, this because the impugned order before the writ court was passed without following the principle of natural justice. And, my lords, there was an report which was in my favor by the state. It has never. My lords, and sorry, my lords.
This writ petition was
By myself, my lords. Because I was the respondent in the original proceeding.
No.
My lords, I was not heard and order was passed.
You can challenge that.
No, my lords. No, my lords, that second contention, my lord, lordship may kindly appreciate. Lordship may I submit, my lords. My lords, may I submit, my lords. Lordship may allow me. My lords, yes.
NGT, national bills.
You will not become appellate authority.
No, lords, it is not about appellate authority.
Mr. Behra,
Yes.
please understand,
Yes.
we are in latest pattern.
Yes, my lords. My lord.
We are not appellate authority.
No, my lord.
Again and again, we are warning.
Yes, my lords.
So keeping that in view,
Yes, ma'am.
our perspective
Yes.
and domain to entertain this
My lord,
sort of order.
Yes, my lords. On the date of admission, on the other day also, your lordship.
Be careful
heard-
in that.
Yes, my lords. My lord, there are other judgments of various high courts where, my lords.
I am not on that.
No, my lords. What I'm saying is, lordship may submit, my lords. The lordship has appreciated the fact the same issue has been dealt with by other judgments.
We are not to appreciate any fact.
No, I'm not on fact, my lords. I'm question of law, my lords.
Where this single judge, learned single judge has gone wrong
Yes.
or qua apparent on the face of it.
Yes, ma'am. Yes. My lords, I'll satisfy your lordship may fix it
Our
for.
scope is very limited, you see.
Yes.
In the interim order, this fact was also noticed by your lordship division bench of this honorable court.
And my lords,
That is why honorable court has directed us to file the counter affidavit. We will file the counter affidavit.
Absolutely correct. It should not be fair.
my lords, lordship may fix it for a hearing. I'll satisfy your lordship.
Here, hearing you.
Yes, my lords. Lordship,
Read to hearing.
my lords, what I'm submitting, my lords. I'll place few judgments, my lords. And my lords, my humble submission is, even though there is an alternative remedy, an appellate provision, that cannot out the jurisdiction of your lordship under 226 and 27. Number one. Second, my lords, here is the case where I have been never given an opportunity of hearing before the.
Can you maintain a writ petition under Article 30?
I'll say 32 minutes. My lords, applying the principle which I would submit, my lords. 32 I cannot, but 226, my lords.
Why not 32?
30.
You are not given any opportunity.
My lords, 32, what I humbly submit, my lords. Any other rights is not, it is only fundamental rights. But I humbly
You mean
submit.
to say that you mean to say that we are extension of 226?
No, my lords. No,
That is what we are arguing.
Lordship may fix it to tomorrow. I'll satisfy.
We are in
Let's
It is not done.
Let's tomorrow. Lordship may fix it, my lords. Today the counters were not there, so I'll.
No requirement of counter. We will not take any.
But tomorrow, Lordship may fix it tomorrow. I'll.
Requested on behalf of the applicant, is this matter tomorrow?
Yes.
Can it be on Monday?
No, let it.
Item 21.
May I please, Your Lordship? My lord, since the counter affidavit was filed to this writ appeal, I had prepared a rejoinder, a copy of which I have already served on the respective contesting party on 5th of this month. With Your Lordship's kind permission, may I file it, my lord?
Counter affidavit.
Where the contesting respondent number 5 has filed a counter affidavit to this writ appeal, though in the first place, my lord, counter affidavit may not have been filed, where it is to be considered on the basis of what was available there before the honorable single judge.
So we
Since,
will ignore that.
as Your Lordship pleases.
You can ignore. You will
Right.
file counter affidavit.
The respondent number 5.
I may pardon, I am on behalf of respondent 5. On behalf of Mr. M. Balkrishna Rao, kindly taken after launch, my lord. After launch.
You will address the court after the lunch.
Yes. I am on behalf of Mr. M. Balkrishna Rao.
And he wants that he would address the court at 3 then.
After launch.
So we shall accordingly prepare the calendar. Or fix the timing.
Is the otherwise. Delays.
And why counter affidavit? The counter affidavit was filed in the.
Well, I am on behalf of M. Balkrishna Rao.
Fine. In fact, the Honorable Single Judge disposed of the writ petition, despite the fact that it was brought to the notice of the Honorable Single Judge that the appellant had already been granted with the temporary permit. So a right had accrued. So I was not implicated as a party. Amendment application was filed to quash my temporary permit that was granted. That amendment application also possibly has not been disposed of, nor I was implicated as a party. The writ petition was disposed of directing for reconsideration, though appeal is available against the order which was challenged in the writ petition. First of all, appeal is available. Secondly, I was also not heard in the writ petition.
Your respondable?
5.
Okay.
Item 22.
Wait, please, just a lot, sir. So may see the last two orders. That the state wanted to file counter affidavit in last 2 occasions, my lord. 2 occasions were given, my lord. Lordship has directed the state.
Yes, why are you not filing?
My lord, I have checked up. My lord, may I kindly hear the writ appeal on merit.
That no, there is no requirement of having a counter affidavit, and this appeal can be decided based on materials available. Yes, please.
My lord. Can I pray, my lord, lordship, may call this matter tomorrow only? Tomorrow, my lord, I need to designate something. My lord. My lord, oblige me.
Item number 24.
Jai Jagannath, sir. First of all, Justice Singh, welcome to the land of Lord Jagannath. Sir, this is a very simple PIL, but I am very it is taking too time to clarify this thing. This is a mere PIL for a footpath and other lacunas of the project. If you go to the history of the case, actually this is the expansion of old Jagannath Sadak, which was passed over the old Authanola Heritage Bridge. In 2015, it was found that the bridge is not suitable for one traffic. Therefore, another single lane bridge was constructed by the side of this old bridge. And sorry, this is not in 2015, this is 90s, late 90s. And due to the heavy traffic, in 2015, it was decided to expand the road. And actually, at that time, it was the only entry to the pool town. And by that time, it was expanded for 2 lane. And another single lane bridge was considered by the side of the Authanola, old Authanola. And it may be mentioned, I agree. Actually, at that time, it was required for 4 lane.
Yes, do it for the states.
State, I am for the state.
That really you will have to provide.
No, sir, that I affidavit, I filed the affidavit to Australia.
Yes.
There, I filed the affidavit on 12th of October 2023. There I have given the details. We are planning the second bridge, and there we are providing for footpath.
Have you filed?
I filed an affidavit.
You have filed the affidavit?
Right.
When did you file?
12th of October 2023.
Have you given him a copy?
Yeah. Sir, actually,
Just a minute, sir, please. Have you received a copy of the counter affidavit?
ଆପଣ ସରକାର ଯୋଉ ଆଫିଡେଭିଟ ଦେଇଛନ୍ତି ପାଇଛନ୍ତି?
sir, ମତେ କହୁଛନ୍ତି sir?
ଆଜ୍ଞା।
Sir, yeah, actually counter affidavit ମାନେ affidavit counter ବି ପାଇଛି, counter affidavit ବି ମାନେ rejoinder ବି ଦିଆଯାଇଛି।
ଆଫିଡେଭିଟ ଭଲରେ ଶୁଣନ୍ତୁ। ଆଫିଡେଭିଟ ଡେଟେଡ ଅକ୍ଟୋବର 2023। 12th of October 23 ଯୋଉଟା ସରକାର ଫାଇଲ କରିଛନ୍ତି ସେଟା ଆପଣଙ୍କ ଉପରେ ସର୍ଭିସ ହେଇଛି, ଆପଣ ପାଇଛନ୍ତି?
ଆଜ୍ଞା।
Yes. Yes, sir.
So what are you doing?
I've given the details that we have provided for the footpath and we've given the photographs also. Kindly look at, sorry.
Let us see.
Look at.
Your opposite party number 3.
3 minutes. Opinion number 3, paragraph 5 of my counter affidavit, also may kindly look at. It is humbly submitted that old Otharnala bridge is now being used by the pedestrian traffic. And
Which paragraph?
Paragraph 5 of my counter affidavit, page 2 of that counter.
Sir, old Otharnala bridge is never.
Just a minute, we are looking into it. We are also equally concerned.
Sir.
Also got it, ma'am?
Yes.
That it is humbly submitted that old Otharnala bridge is now being used by pedestrian traffic, and in this regard, the relevant photographs are annexed to Annex B/2. Further, it is stated that the tender for the work, improvement to road from Kumbharpada Chowk.
This is page 50.
Improvement of road from Kumbharpada Chowk to NH 316 by Devighat and village Khandiyabandha, including river Musa, is under process. In the above circumstances, the provision of the footpath on both sides along with the new bridge has been kept for smooth movement of pedestrians on the proposed new bridge, and the said bridge to be construction adjacent to the existing old Otharnala bridge.
Yeah, what is the position? What does you?
ପୂର୍ବରୁ ଗୋଟେ ଡାଇଭରସନ ଅଛି ସେଇଠି pedestrian path ଟା କରିବି।
Yes. And so,
that frankly speaking, I have not been able to understand the controversy because it's a local thing. Therefore, I don't know the geography of the area.
Yes, may propose one thing. You can appoint some senior lawyers from this court to inspect the locality which may
No, we will not do that. Just reverse. In fact, he wants that the pedestrians should have some way to reach a particular place, whichever place. It is the court's view that the pedestrians have the first right over any road.
Right,
Right. Any road. What to talk of this road? Over any road, the pedestrians have the first right, and therefore the state government
must make such arrangements that pedestrians can move safely on the road.
Right, Mas.
All right, even like even in the city like Cuttack, there
Right.
should be some provision
Yes.
for pedestrian. His grievance relates to a particular road. What is that?
No, in fact,
Both the ends of the Otranala bridge
Yes.
now is closed.
Yes, because Otranala is now means only for pedestrians, no more movement of any vehicle means. Vehicles are means in fact bifurcated by way of a new road.
They are diverted.
Diverted means on the left side.
Another route is there,
Right.
diverting the path of vehicles.
Yes,
Vehicular
and
traffic.
now also a new bridge. Now a
Just
new
one more, sir.
We will return up. We will
Okay,
come back.
okay,
to you.
okay, okay.
We will come back to you.
Okay.
A new bridge is also proposed to that adjacent to Otranala, where we have stated that we are also making provision for footpath on both sides of that bridge. If that will suffice, my friends.
Mr. Paikle, ବର୍ତ୍ତମାନ ବ୍ରିଜ ଟା ଖାଲି pedestrian ମାନେ ହିଁ ୟୁଜ କରୁଛନ୍ତି।
Sir, ମୋର ମାନେ
ଟିକେ ଶୁଣନ୍ତୁ
rejoinder ମୁଁ ଯୋଉ
ଟିକେ ଶୁଣନ୍ତୁ ଶୁଣି ସାରନ୍ତୁ। ମୁସା ରିଭର ଟା ବର୍ତ୍ତମାନ ରିଭାଇଭ କରିକିରି ସେଇ ଉପରେ ସେଇ ପାଖ ଦେଇକିରି ଗୋଟେ ରାସ୍ତାଟା ଯାଇଛି, ଯୋଉଟା କି ଭେହିକୁଲାର ଟ୍ରାଫିକ ସେପଟେ ପାସ ଅନ୍ ହଉଛି, ଡାଇଭର୍ଟ କରାହେଇଛି ରାସ୍ତା ଭେହିକୁଲାର ଟ୍ରାଫିକ ପାଇଁ। Any vehicle, 2-wheeler, 3-wheeler, 4-wheeler, any vehicle. Only pedestrians are allowed to cross the river through that bridge. They are only the users. So that is the pedestrian path.
That is the pedestrian path, not pedestrian street.
Please, sir. Shuni sir. My lord wants to know.
Yeah.
ଆପଣ ବର୍ତ୍ତମାନ କଣଟା ଚାହୁଁଛନ୍ତି?
Sir, actually ଗୋଟେ ରୋଡ ଯେତେବେଳେ ରହୁଛି, ରୋଡ ସାଇଡରେ ଆମର ସେଫ୍ ପ୍ୟାସେଜ ପାଇଁକା pedestrian ମାନ ପାଇଁକା ଗୋଟେ pedestrian strip ରହିବା ଦରକାର।
ଆପଣ କହୁଛନ୍ତି ଯୋଉ ବାଟ ଦେଇକି ଭେହିକୁଲ ପାସ୍ କରୁଛି ସେଠି ମଧ୍ୟ ଗୋଟେ pedestrian path ରହିବା ଦରକାର, ଏଇଆ ତ?
Sir, ଆପଣଙ୍କର ଅଠରନଳା ଓଲ୍ଡ ବ୍ରିଜ ବର୍ତ୍ତମାନ it is taken by SI, ଯୋଉଟା ମାନେ any time may be closed for public. ତେଣୁ ସେପଟେ କେବେ ବି ଆପଣଙ୍କର ମାନେ ପବ୍ଲିକ କି ବନ୍ଦ କରାଯାଇନଥିଲା, pedestrian traffic ଯାଉଥିଲେ, କିନ୍ତୁ ଏନି ଟାଇମ এটা ବନ୍ଦ ହେଇଯାଏ। Sir, I have already given the sketches and maps. You can see it.
Now revise. And this
Samantra, there is a scope for this bridge
No.
may collapse at any time
Right, no.
unless it is preserved.
Yes.
Right?
Yes.
So what he says, I understand that if pedestrians are allowed,
No.
that can also be someday or other, that can also be stopped.
Right, no.
As vehicles
Yes.
now have been completely
Yes,
previously two-wheelers were passing.
Right.
Now that two-wheeler is also stopped.
Yes.
So another road via Musa River,
No.
which is structured. So he wants that pedestrian path to come alongside that.
Right, no.
Right.
Yes.
So there is no pedestrian path now.
Yes, that is true, no. Yes.
So that,
Because in fact,
that is what he wants.
That is why we have said the new bridge adjacent to this, so which we are going to
Another bridge is going to be
constructed. There will provide for that
pedestrian.
We are now
So
archaeological.
for now, what will you do?
Then you'll also give me some time after, because ASI has already taken over that old bridge for preservation.
Then they can stop human movement also.
For preservation purposes.
For preservation.
Yes.
So it has to be
now we have to give a status.
Unless you protect this, it has some relation to religious
yes, sentiments of the public, because Othanwala is your.
Sir, we have gone through your affidavit.
Right.
Saying that the Archaeological Survey of India has stopped
Madam.
even pedestrian movement on the bridge, old bridge. All right.
Yes.
This is one. The other is that you have not provided any track on the bridges which have been built in 2008 and 10.
No.
This is what you say.
It is not bridge.
2015.
It is diversion road.
This is a diversion road, not a bridge.
not a bridge.
Exactly.
Please come to paragraph 5.
Yes, no. Yes, it somebody submitted that old Othanwala bridge is now being used by pedestrian traffic.
Paragraph 5 of your counter affidavit.
Yes, no.
Somebody submitted that out of the twin bridges. Paragraph 5.
Sir, that is mine. That counter affidavit is mine.
That is his.
That is his counter affidavit.
Yes.
That is his affidavit.
Affidavit.
Counter affidavit. Sorry. Where is your counter affidavit?
Mine
Page 34 to 36. 21/9/2023 already.
Yes.
Opposite party number 3. Additional affidavit as per order dated 21/9/2023.
No, yes, 12/10/23. It's filed on
12/10/23. Yes. Page 34, 36.
No.
Sir, these all things are already discussed. Please kindly go through this court's order 21/9/23. This court's order.
Please, sir. Please. Mr. Paikre, please.
Yes. So that has not been stopped by the ASI, according to you.
If only I've given the photographs. Only pedestrians.
Photographs, if you are allowing something to.
And Othanwala old bridge is never barred by the ASI for public or pedestrian traffic. The question is that it is a historical monument taken by the ASI, which can't be used as a public footpath or public pedestrian street. And for maintenance region or for any region, it can be.
Mr. Pakre, we are trying to understand your difficulty. Let us
permit us to resolve it. Don't interject.
Sir.
So from your submission,
Yes.
what we could understand,
Yes.
that you are now trying to have another bridge
Yes.
parallel to Atranala,
Yes.
so that that can be used vehicles as well as pedestrians.
Pedestrian.
So for now,
No.
the diverted route which is used for vehicular movements, there, do you have any proposal for pedestrians to move?
That existing diversion. No.
Existing diversion.
That instruction I will take me also grant me sometime.
And you will have to do something.
Yes, ma'am.
Yes, Mr.
My lord, we have implemented as a party on 21/9/2023. The direction was given to the other side to serve a copy. They didn't serve the copy. As well as they, whatever counter they filed, they didn't serve. I already said for our department officials to give the proper instructions in this regard. And to direct my lordship give some time. And then meanwhile, they let them serve the whatever counter they have served, everything they will serve.
And what is the length of that?
Yes, detail affidavit we can file also.
500 around 500 meters.
And what is the width?
Sir.
No.
Original bridge, not that autonomous bridge.
No, not bridge. The diversion.
Diversion is sufficient, not both ways. Not ingress or egress.
What is the length of that diversion?
Length of diversion maybe not
700,
700 or 800 meters.
And width?
Width is not 30, maybe 60 meters because it's a two-way not so given this or that way also.
So can something be done for the pedestrians on that?
That I will find out. If pedestrian proposal.
The space is there. If something can be done, if it is planning it to be done.
No. Today you may say the space is there, but during Ratha Yatra, it is very difficult, very difficult.
Very difficult to, yes. Ratha the exception, yes. Many festivals was there. That time,
other festivals.
5-6 festivals there in that Ratha Yatra plus 5-6 festivals.
So,
Chandan Jatra.
Floating population you can't control.
Yes.
At any moment there will be floating population. So ingress and egress to that, Puri town, that is the only way. That is the only.
During Ratha Yatra, the traffic
Nua
road
is
Talabani.
But nobody takes that. Normally, people are used to this path only.
Only two-wheelers, because four-wheelers are never.
Why is he using this expression, bridges over Musa River? There is no bridge over Musa River?
That was the only bridge, the Atranala bridge, which now become a monument. That was the original bridge over River Musa.
No, whether there is, please come to paragraph 1 of the writ petition.
To provide pedestrian for the road safety as well as on the bridges over Musa River at the Garden Square Atranala. That is the only bridge, I think, Musa River.
They are contemplating to construct another parallel bridge. It has not yet been sanctioned or.
No, sanction has been made. Tender, it has not yet been.
Sir, it is also around us. Sir, parallel to Atranala, no bridges can be constructed. There, Lord AGA is telling about another bridge. Please go through my counter affidavit. I have given the sketches and the maps. And everything will be clear from that.
All right, please listen.
Sir, all these things are.
Listen to our order. The petitioner has filed present writ application in the nature of public interest litigation, seeking a direction to the opposite parties, particularly the state of Odisha, to provide footpath for the pedestrians Footpath. Footpath slash pedestrian strip for the pedestrians on the bridges over Musa River at Garud Square, Atharnala, Puri. Next. It emerges from what has been averred in the writ petition and the writ petitions and the affidavits filed on behalf of the parties in the present proceeding, as also the submissions advanced at the bar, that there is Atharnala Bridge over Musa River,
Right.
which is of archaeological importance.
Right.
First off, the said bridge has been closed for traffic movements.
Right.
First off, it is the stand of the state government that the said old bridge is being used by the pedestrians
Only. No.
for pedestrians.
Yes.
First off, the petitioner, on the other hand, contends that the Archaeological Survey of India has stopped movement of even pedestrians over the said bridge. Full stop. It appears that a road has been constructed in the nature of diversion by the state government adjacent to the bridge. Not almost adjacent to the bridge. Parallel adjacent / parallel to the bridge. So stop. It is in that background the petitioner's contention. It is in that background Mr. Pakre, petitioner in person submits that over the diversion, that on the diversion road, there should be some space provided for there should be some facility for the pedestrians by having footpaths. So stop. Next, in the counter affidavit which has been filed on behalf of the state of Odisha, it has been mentioned that in future, if there is any plan to have a bridge over Musa River, provisions shall be made. Footpath shall be provided. Stop. Next. Be that as it may, keeping in mind the urgent need of pedestrians for crossing that bridge, crossing the river. Crossing the river, we direct Who is the authority?
That's the lodgement at OP number 3, my lords.
The opposite party number 3, particulation. To file an affidavit stating specifically as to what urgent steps can be taken for providing footpath over the diversion road adjacent to which adjacent to Athra Nala, yes, comma Puri Bridge.
No, Musa River
Athra
at Garuda Square.
क्या लिखा?
At Garuda Square,
Adjacent to Musa River at Garuda Square, comma Athra Nala, comma Puri. Is it correct? Full stop. Such affidavit must be filed within 3 weeks. List this case on 3 weeks within first 5 cases. Full stop. Next, in the meanwhile, let learned Deputy Solicitor General of India seek instructions from the Archaeological Survey of India as to whether the old bridge has been closed for the pedestrians also.
সেটা ঠিক আছে মুসা রিভার গরুড়া
Keeping in mind
Sir,
archaeological importance.
Sir.
Yes, sir. Yes, please.
sir, please go through this court's order 21/9/2023. All these things are already over. They have already filed the counter, and I have the rejoinder, and the court has what the court orders.
Mr. Pakre, please appreciate
Sir,
that by our order nothing can happen.
sir,
We can just assure you that we shall monitor. We are also interested in public interest of the people,
sir.
in the interest of the petitions also. So
Sir.
we have issued certain direction. Let us see what happens. We have
Sir.
asked them.
Sir, in
Tell
between,
what can be done.
sir, in between many things have already happened. I have already 2 IAs are there, and other irregularities are also there. I have 2 IAs, one for on.
Mr. Pakre, please, we are just trying to convince you for the present
Sir.
that by deciding your case, nothing will happen. Something should happen on the ground.
Sir.
And we are taking some steps.
Sir.
Let us see what stand is taken. If required, we will pass appropriate orders.
Sir. No, sir, for that, the construction work of the road should be stopped.
All right.
Let them file whatever document they filed the court, let them serve to us also. My lord directed.
In the meanwhile, the pleadings be exchanged.
In that earlier order, this court was exploring possibility of foot over bridge near Garuda School. That is what he was claiming. So that will
In the affidavit, opposite party number 3, will also state as to whether any decision has been, any attempt has been made to have a new foot over bridge at Garuda Square. What difficulty do you have in having a foot over bridge?
There may be some difficulty because on one side there is not this diversion road, and on the right side this is river mirrors. So people cannot go from this side to that side. It has to be either straightway or foot over bridge, which will be equally.
The other side of the diversion, Musa. So there is a difference.
Let your lordship's order be there. We'll also explore if there is any possibility. Lords.
One week, then we are keeping it after 1 week.
Yes.
1 week.
Product Development Authority is opposite part number 5. Mr. P.K. Mahanti was appearing earlier. He is not in a position to conduct the case.
What happened?
Suffering. So I got information from my learned friend and immediately I contacted to office. And this is the position, case has been listed, kindly attend. They instructed me to appear, take some short adjournment so that we can collect file from him and we will be able to assist my lords. That is what my humble request, my lords.
And CDA is the most contesting opposite party. That they have filed the counter affidavit, everything.
The CBA has only filed the counter affidavit, state has not filed.
The only embarrassment which the court is.
It's an old matter, my lords. It's an old matter, my lords. Yes, my lords.
And we are in 2024.
Yes, my lords. This is an old matter. That to my lords, the matter relates to some 100 odd acres over which my lords. Anyway, whatever the matter may be, the whole total project of Kotak Bidanasi project has been developed in that process. But anyway, my lords, just whatever I gone through the documents and records. If I will not be able to get it from him also. 20.
Settled in our.
20 acres of the land over which.
Talk in chorus.
No. He said that 111 acres.
Whatever.
Let him say.
So, my lords, I be permitted so that I will collect and build up my cases, my lords.
Requested on behalf of the Kotak Development Authority by way of last indulgence. The matter is adjourned to 1 week. It is made clear that the court shall not grant any further adjournment, keeping in mind the fact that this matter has remained pending for nearly 24 years. Yes.
What's fixing it, my lords?
1
Fixing.
week.
27.
27th.
27.
March. December.
Not to
That 27.
28.
What's it, man?
Would it be, my lords,
First week of
first week of April, my lords, I think.
First week of April, all right. 4th of April. 4th of April.
4th of April will do. 4th, my lords, May payment 3rd of April.
3rd of April.
Okay.
Third, I have some.
All that I'll accommodate 4th. After 2, I have come.
4th April at 2 p.m.
2 p.m.
2 p.m. So we take about 2 p.m.
Item number 23.
Wait, please, Your Lordship. Lordship, we have received a copy of the affidavit as your lordship directed on the other occasion, the government has to file an affidavit. We have received that. This, in addition to that, your lordship, we have filed also an affidavit detailing the further developments during pendency of this appeal, your lordship. And a note, your lordship, further note, your lordship. Yes.
From number.
Yes.
Your lordship. Your lordship, in this, your lordship may kindly recollect, this is a matter related to two DPCs conducted in 2023 and presently at 2024 in pursuance of our lordship's direction or the grant of leave. They have conducted another DPC matters. Now, your lordship, I had drawn your lordship's kind attention on the last occasion by filing an IA, your lordship, which is at 863 of 2024. Flag F, your lordship. And there I had pointed out that several persons who are ineligible, they have been included for consideration by the DPC. And your lordship very rightly said, it is for the DPC to consider. We are not going to do anything to do with that. Now, your lordship, the today's affidavit which has been filed by the government, your lordship may kindly just refer to page 16 of that affidavit, my affidavit, your lordship, my IA, your lordship, that annexer 3.
IA you have filed.
IA, your lordship, on the last occasion I had filed. That is at flag F, your lordship. Sorry, 863 of 2024.
Yeah.
Well, in that case, your lordship may kindly come to page 16, your lordship, 16 of that IA.
Yes.
Serial number 2, your lordship, Vijay Kumar Malik. And the last column, your lordship, finds year of promotion from the rank of FR and joining as SCF after completion of training. It is 2023. Your lordship may kindly note 2023. And another person, your lordship, serial number 5, Saroj Kumar Bishwal. His year of getting promoted to the post of SCF is 2019, your lordship.
Yes.
And as your lordship finds today's affidavit by the government, your lordship, they have produced as annexer A1 the notification dated 13/3/2024. Affidavit filed on behalf of the respondent number 1 in response to order dated 7/2020. In that affidavit, your lordship, page number 9. Both the persons whom I pointed out to my lords, your lordship, Vijay Kumar Malik and Saroj Kumar Vishwal, they have been at serial number 1 and 2 in that list, your lordship. And from the very beginning, your lordship must have recollect, your lordship may kindly recollect, that the eligibility clause is 5 years, completion of 5 years of continuous service, as on the date on which the DP, in which the year in which the DPC is being held. And as against this, the affidavit, your lordship, shows, lordship may kindly come to page 7, para 10, the government's affidavit, today's affidavit. Lordship. Page 7, para 10, Your Lordship. It is pertinent to mention here that in pursuant to the aforesaid order dated 29/2/2024, it should be 28. A fresh DPC has also been convened on 11/3/2024 as per the observation made in para 21 of the judgment passed by the Honorable Single Judge, and the DPC have already considered the cases of eligible officers who have completed 5 years of service as SCF as on 01/01/2024. But these two persons have not completed the 5 years, Your Lordship, as on date, Your Lordship. As unfortunately, what has happened?
Who have not completed?
My lords, these 1 and 2, serial numbers 1 and 2. Serial number 1 was promoted in 2023 and serial number 2 was promoted in 2019. So he will be completing 5 years on 1/1/25, Your Lordship. As per the eligibility clause, rule 5, Your Lordship, 2015 rules.
So why have they been considered?
I don't know, Your Lordship.
We are also not representing them because we are for the general candidates.
No, these read petitions have also, there is no, the read petitions have been promoted.
There's nothing vis-a-vis me, like.
No,
We can understand.
No.
The only question is that if a rule has to be applied,
correct,
that will have to be applied uniformly.
Right.
So what is the circumstance in which and
there's nothing written in the affidavit, Your Lordship, with regard to 1 and 2.
there is no pleading based on your knowledge which you have. They have completed 5 years.
Yes, my lord, they were notionally promoted.
Notionally? What is that?
Because there
Notionally
was,
promoted.
yes, there was delay, and as I get the immediate
All right,
question, because they were not party here, so I have not actually, I had not
All right,
entered into
that
my
was not
senior state. So immediately I took instruction.
All right. And that is not question.
Yes, please.
And Your Lordship wanted to know on the other occasion that what has happened, what is the status of 2023 DPC? That is why Your Lordship had sought for an affidavit. And Your Lordship may kindly come to para 7 of this today's affidavit, Your Lordship. That's also stated by me in my affidavit. Para 7, Your Lordship. The proceeding of the DPC, which was held on 23/2023, has been approved by the state government on 19/10/2023. And thereafter, 2 of the eligible officers, namely so-and-so, have been promoted to the rank of DCF as per the DPC held on 23/2023 in compliance to the direction of the Honorable Single Judge on 4/9/2023 passed in IA number 1.
As I pointed out on the last date to my lords, these 2 persons are undisputedly senior to all.
No,
to all the parties present.
That's right.
I
no dispute
pointed
about
out on the last date to my lords.
So what will happen if we interfere with the order?
No, I'm not saying that Your Lordship will interfere with this order, Your Lordship.
No, not this order. Interfere with the order of London Single Judge.
It has to be, Your Lordship. It has to be interfered with. Because, Your Lordship, the Honorable Single Judge has gone on a footing that this is kept for reserve candidates, so arbitrary exercise of power, which has been specifically denied by the government. As also Your Lordship found on the other day that it cannot, because general candidates were there along with us, Your Lordship, who had been promoted, but all of them were found eligible. That is also submitted by the government in this present affidavit, Your Lordship. They say that in para 5, they have stated, in pursuant to the aforesaid order passed by the Honorable Single Judge, DPC was held on 23/2023, wherein 30 officers are found eligible, having completed 5 years of service in SCF cadre as on 1/1/2023, as required under Rule 5 of the 2015 rules. There is no illegality here as it is, Your Lordship. But for the direction or the observation of the Honorable Single Judge, that minus 2 persons, the rest of the candidates, they will not see the light of the day, Your Lordship. But fortunately, most of them, they have now been covered in 2024. Only the appellants, 5 numbers, they have been now left out, Your Lordship. And if Your Lordship considers that 2023, these 5 also will get it, Your Lordship. And there will be no quarrel over in the parties, Your Lordship. Cannot be, Your Lordship. And if it is not devoid of any irregularity, Your Lordship, my humble submission before Your Lordship will be that it should not have been interfered with. It should have been kept as it is, and whoever comes eligible, 2024, they have considered, they have also selected, and they have been posted, they have given postings, they have already joined, Your Lordship, on 15th. And that is there in that order itself.
You'll see.
This is the only, I am only faced with this predicament only. Because they have shown me in.
As we have understood, your submission is that by the indirect effect of the judgment of London single judge is that your promotion based on reservation.
No, this is not based on reservation. This is not on reservation. This is direct.
No,
earlier. Earlier. Okay. Okay.
Your promotion based on reservation has been taken away.
No, my lord. Oh, ACF, I am there as ACF, continuing. My learned friends, candidate clients, they are also continuing. We had been associated as ACFs only. We had been promoted earlier, they have been promoted later, but by virtue of the catch-up rule, Your Lordship, seniority list has been redesigned. Where we stand junior to them as the forest ranger, the seniority list which was there. We have only restored that only. Now with the promotion where we have been found eligible, and we have been also found eligible as per the DPC, we are not going to give given the promotion because 2024, they are considering our case, we are standing much below them, Your Lordship, in that list. Wherein Your Lordship finds
the entire logic of the learned single judge is based on the fact that promotion could not have been granted to you.
Yes.
Based on reservation in the light of the Supreme Court's decision in case of Nagaraj.
No, my lord. He says that Nagaraj principle is not applicable to the case, Your Lordship. Clearly says that is not applicable, Your Lordship. But he says, Your Lordship, I will take Your Lordship to that particular para, Your Lordship. And I have given that further note today, Your Lordship, brief note, Your Lordship. Your Lordship, may kindly have a look.
Where is that?
I have given today, Your Lordship.
No, the judgment.
Judgment, Your Lordship. Judgment, Your Lordship finds. Yes. Yes. Yes.
Page 15, yes. Submissions are noted.
Submission. 53 starts from 53, Your Lordship, para 17, Your Lordship.
Yes.
Now the question is whether the principle of reservation is sought to be extended by the authorities in the proposed promotion. The impugned communication under Annexure 1 on the face of it does not say so. The State Council as well as the learned Senior Council appear for the private opposite parties have emphatically argued that the principle of reservation is not sought to be extended for promotion to the rank of DCF. Rather, the promotion is sought to be made by invoking the eligibility clause. This being the fact situation, the decision cited by Sri G. Mishra in relation to the applicability or otherwise of Article 16(4)(a) of the Constitution would not be relevant at all. To amplify the need for obtaining quantifiable data by the state regarding inadequacy of representation of reserved category persons in public service being sine qua non to apply the principles of promotion with consequential seniority to them as envisaged in M. Nagaraj, so and so are rendered redundant. This is the observation by the Honorable Single Judge. Yes. Thereafter, Your Lordship, the Rule 5 is quoted, Your Lordship, in para 18. The rule provides that an officer.
So this is what the learned single judge observes.
Yes.
that to amplify the need of obtaining quantifiable data by the state regarding inadequacy of representation,
Yes.
so and so are rendered redundant.
Redundant. Your Lordship also said the same thing also on the other day, Your Lordship. Because they are now harping that Nagaraja's principle has to be applied. Because it has not been applied, so whatever the learned single judge says, that
Learned single judge says that it ought to have been applied.
Then
Is it?
rendered redundant.
yes, my lord, thereafter, my lord may read. The main reasoning is thereafter.
I'm giving.
Para 18.
Please let him. Please let him.
Yes, Your Lordship.
May I please?
Please let him go.
Just
My lord,
let me complete. Let
I'm
me
so
complete. Thus, the rule provides, Your Lordship, I am reading from 54 last year, 2 lines, after quoting the rule. Thus, the rule provides that an officer shall not be eligible for promotion to the post in senior branch unless he has completed 5 years of continuous service in the junior branch as on the first day of January of the year in which the board meets. The proposed promotional exercise being scheduled to be held in the current year, that is 2023, the relevant date for consideration of eligibility would be 1st January 2023. Admittedly, as on that date, the private opposite parties had completed 5 years of continuous service, whereas the petitioners had not. Thus, prima facie, they are not eligible for being considered for promotion to the senior branch. But then, if only the eligibility clause is harped upon and the proposed promotions are effected, it would entail a situation where the private opposite parties, who by virtue of the principle of reservation had been promoted to the junior branch earlier than the petitioners, general category candidates, would definitely steal a march over the petitioners. Since on the face of it and record, the principle of reservation would not be applied in case of promotion to the post of DCF, the catch-up principle also would not be applicable if and when the petitioners are promoted to the senior branch. In other words, this would lead to a situation where the inherent seniority of the petitioners, restored by application of the catch-up principle in the year 2022, would be lost forever. This is what has been said, Your Lordship. Sorry. To further elaborate, the private opposite parties who are inherently junior to the petitioners but had marched ahead of them by virtue of the principle of reservation would become seniors to them for all times to come. According to the considered view of this court, this would be entirely...
That we remember.
Yes, ma'am. Your Lordship remembers this, Your Lordship. Then Your Lordship comes that the next para, Your Lordship, in its judgment rendered in the case of Ajit Singh Januja versus State of Punjab, 96 Supreme Court, the Supreme Court's following observations are noteworthy. Whenever a question arises for filling up a post reserved for scheduled caste or scheduled tribe candidate in a still higher grade, then such candidate belonging to the scheduled caste tribe shall be promoted first. But when the consideration is in respect of promotion against the general category post in a still higher grade, then the general category candidate who has been promoted later shall be considered senior, and his case shall be considered first for promotion, applying either the principle of seniority cum merit or merit cum seniority. Here, Your Lordship, the cue which has been lost is provided he is eligible. That is not there here.
The main question is as to whether someone who is ineligible in accordance with the rules can be considered for promotion. In any circumstance. Either the rule is bad, the rule can be challenged, or whether the court can issue any direction contrary to the rule. That
is exactly it. Now the situation has now turned different now, because that particular clause no more applies because they have become eligible as on 1/1/2024, Your Lordship. That is the direction of the Honorable Single Judge, Your Lordship.
Yes.
Your Lordship, again, the same thing has been said that what could not be directly done by the state is attempting to do so indirectly, which is needless to say is not concernable in law, Your Lordship. Then, Your Lordship, para 18, Your Lordship, I'm sorry, 21, Your Lordship, page 58, my Lords. How then to go about it? Yeah, Your Lordship gets it. Yes. It has been argued by the Learned State Council that there being a large number of vacancies in the Act of TCF, the posts need to be filled up at the earliest for the overall efficiency and smooth functioning of the work of the department. This court finds that the petitioners having been promoted to the junior branch on different dates in the year 2018 have acquired or will be acquiring the eligibility on different dates in this year itself. Moreover, we are at the fag end of the year 2023. As on 1st January 2024, the petitioners would have acquired the required eligibility. Thus, taking a larger view of the matter, and in order to satisfy the requirements of the law of the land, this court is of the view that it is felt necessary to grant promotions. If it is felt necessary to grant promotions to the rank of DCF urgently, then the government can relax the eligibility criteria promotion to the senior branch basing on the final gradation list as on 9/9/2022. Significantly, 2015 rules provide such a clause in Rule 15. This is a relaxation clause, Your Lordship. Then, Your Lordship, I'll take Your Lordship to 22, para 22, Your Lordship, because from this the directive comes. Since filling of the post, page 60, Your Lordship, since filling of the post of DCF would be in public interest, the government shall do well to consider relaxation of Rule 5 in exercise of its power under Rule 14, or in the alternative, to defer the promotional exercise to a date after 1st January 2024, so as to consider all officers as per the gradation list as on 9/9/2022. This is an error, Your Lordship, may kindly note. Here the note is that to consider all officers as per the gradation list as on 9/9/2022, that will be irrespective of the eligibility clause, Your Lordship. This is the directive. So I may humbly submit that this is an error on record, Your Lordship, because unless Your Lordship also says, unless someone is eligible, he cannot be considered, Your Lordship. So all officers who are found eligible as on 1/1/24, that should have been there, but that is not here, Your Lordship. In view of the foregoing narration, this court is left with no doubt that the impugned commission under Annexure 1 being a product of arbitrary exercise of power. I am against this observation, Your Lordship. How can this be arbitrary exercise of power, Your Lordship? That I have to prove. Cannot be sustained in the eye of law, inasmuch as it indirectly seeks to grant the benefit of reservation in the promotional post to the juniors like the private opposite parties, ignoring the inherent seniority of the petitioners as correctly reflected in the gradation list. Thereafter, the ultimate direction is there, therefore allowed. The impugned communication is hereby quashed. The opposite party authorities are directed to necessary steps to fill up the post in the promotional cadre, that is DCF. In terms of the observations made in this judgment, it is made clear that if any promotion has been granted to any officer pursuant to orders dated 12/5/23 and 4/9/23 passed by this court, the same shall remain unaffected by the judgment.
Yes.
And Your Lordship, as against this decision, Your Lordship, and this judgment, Your Lordship, I have filed this further note of submission because my learned friend has also filed another note. So I had, Your Lordship also permitted us to file the additional note, Your Lordship. Today I have filed. So I am 4 categories I have stated, Your Lordship. First is that inapplicability of the decision of named Nagraj to this case, Your Lordship, that I indicated. And seniority cannot override eligibility, Your Lordship. That also, Your Lordship, conferred with me because I have also cited dissents. There are 2 aspects and 2 different considerations altogether. Seniority vis-a-vis eligibility.
All right, we will see, Mr.
And thereafter, Your Lordship, apparent error of record. Therefore, that all officers as on 9/9/2022, that is an apparent error on record, Your Lordship. And Your Lordship, my learned friend has cited that some delay and latches are there which are to be condoned. Because you see, the important aspect, Your Lordship, is that they have never challenged the promotions, Your Lordship.
Yes.
Never challenged the promotion, and they have sat quiet, Your Lordship. And in the writ petition also, there is no whisper with regard to challenge with regard to our promotions.
Yes.
That is the admitted fact, Lords. So these admitted cases of delay and latches that will no more survive in the cases, Your Lords. That's what I have indicated. My humble suggestion, as I have laid on the last occasion, Your Lordship, my humble suggestion will be, if your Lordships permit me, that 2003, and my learned friend on the government rights, they have stated that this DPC has been approved by the government. 2023, yes. 2023 has been approved by the government. So it is complete, Your Lordship. So once it is complete, Your Lordship, and 3 of the officers who had been also promoted after that also, so the rest cannot be also sorted out, Your Lordship, shunted out. So that will be my humble submission. So 23 and 24, if they are taken together and also published on the same day, but to 24 they have already published. But my humble submission is that 23 also being published, Your Lordship, all the appellants also, they can be promoted and there will be no rancor in the department. That will be my humble submission, nothing more, nothing less. Because most of the opposite parties who are there in the writ petition, they have also been, their cases have been considered in 2024. They have been considered in 2023. They have also been promoted and directed to join your lordship. They have already joined my informational post, your lordship. So only 5 are left out, your lordship. That's it. It is up to your lordships to consider.
Yes.
What falls from my learned senior now, last words, they are a kind of a conciliatory approach where he says that 23 may be considered along with 24, which the Honorable Court also proposed at one point of time during the course of hearing, saying that both the lists can be considered, and then thereafter this becomes a question of seniority. They would be senior to us. That is probably that's what we are headed towards if both the lists are considered. Now, I bow down to that suggestion, my lords. I would leave it to the court. That is, of course, that's something that's not going into the legalities of it.
No, we will have to go into the legality.
My lords.
That is the difficulty with us.
My lords. Now, so far as the legalities are concerned, my lords, as it fell from the court, there are 2 issues which we have tried to highlight in that additional note, which is at flag G. We had given our main notes earlier, indicating about Nagraj and UP Power, where they said that this exercise is mandatory. Unless this exercise is done, you cannot have reservations in promotions. Now, UP Power is, of course, not a constitution bench, but Nagraj, I need not say, my lord, it's a constitution bench judgment. Subsequently, Jarnail Singh, also constitution bench judgments. Pravakar Malik, we have given it in our first set of notes, all these judgments. So may I show those paragraphs, my lord, from UP Power, where they say that this is mandatory? The first set of notes are there. Now, this began with 1993 Indra Shone. Both the notes are digitized, it says in the list also.
It's 15. No. Take. Yes.
Flag X is the main note, and thereafter at flag G is the additional note. So may I refer to the main note which we had given, and my lord may just see M Nagaraj, the pages would be page 87 of that note.
Page 87?
87. It's a compilation of judgments, that's why it became lengthy. My lord had dealt with M. Nagaraj also in Patna High Court.
Yes. Long back.
Yes. We have got that judgment also, but that was relating to a different question. So far as this reservation in promotions.
Oh, that was in relation to medical colleges or something.
We have got that. Dr. Sudhir Kumar versus.
That was in a different context altogether.
In a different context.
Computation of backlog vacancies, I think.
Here, Nagraj, the question is formulated. I hope my lord gets page 87 of that first set of notes. The question has been formulated in paragraph 2.
Yes. Yes.
The petitioners have invoked Article 32 of the Constitution for a writ in the nature of certiorari to challenge these amendments. According to the petitioner, the impugned amendment reverses the decisions of this court in Union of India versus Virpal Singh Chauhan, Ajit Singh Januja versus State of Punjab, that is Ajit Singh 1, Ajit Singh 2, Ajit Singh 3, and so on. The petitioners say that the Parliament has appropriated the judicial power to itself and has acted as an appellate authority by reversing the judicial pronouncements of this court by the use of power of amendment as done by the impugned amendment, and is therefore violative of the basic structure of the Constitution. Said amendment is therefore constitutionally invalid and is liable to be set aside. Then my lord may kindly see page 114, the conclusion. I'll straight away take my lords to the conclusions. Before that, in para 85, page 114, the Constitution bench records what was held in Indra Sawhney, para 85. That is at page 114 of that compilation.
Yes.
The Supreme Court in its judgment dated 16/11/1992 in Indra Sawhney stated that reservation in appointments or posts under Article 16(4) is confined to initial appointment and cannot extend to reservation in matter of promotion. Prior to the judgment in Indra Sawhney, reservation in promotion existed. The government felt that the judgment of this court in Indra Sawhney adversely affected the interest of SCs and STs in services as they had not reached the required level. Therefore, the government felt that it was necessary to continue the existing policy of providing reservation and promotion confined to SCs and STs alone. We quote here in below the statement. So thereafter, they have quoted that. Then my lord may kindly see page 131 for the conclusions of the Honorable Supreme Court. They held the amendments to be intra-virus subject to certain conditions. Now, those conditions would be important. They are at page 131 of that compilation. Para 121. May I place that?
Yes.
The page 120, para 121. That is page 131 of that compilation.
Yes.
The impugned constitutional amendments by which articles so and so have been inserted flow from Article 16. They do not alter the structure of Article 16(4). They retain the controlling factors or the compelling reasons, namely backwardness and inadequacy of representation, which enables the state to provide for reservation, keeping in mind the overall efficiency of the state administration under Article 335. These impugned amendments are confined only to SCs and STs. They do not obliterate the constitutional requirements, namely ceiling of 50%, quantitative limitation, or the concept of creamy layer. The subclassification between OBCs on one hand and SCs and STs on the other hand, as held in Indra Sawhney, the concept of post-based roster inbuilt in so and so in RK Sabharwal. We reiterate that the ceiling of 50%, the concept of creamy layer, and compelling reasons, namely, now this backwardness word is taken away by way of journalcy, so this would not come, namely inadequacy of representation and overall administrative efficiency are all constitutional requirements.
No, there is no quarrel over what was laid down in Nagaraj. The only question is that rightly or wrongly, they were granted promotion by giving them the benefit of reservation. You did not question that. Now, when it came to the grant of this promotion to be considered by the DPC, you are questioning that they were wrongly given promotion. So unless it is held that those promotions were illegal, contrary to the law laid down in Nagaraj, it is very difficult to grant you relief.
Of that promotion. And then the court balances it out by saying that either you relax as you have done in other cases, because the single judge also records instances where relaxation of 2 years, 3
No,
years.
is there any provision under the rules
Yes,
for
yes,
relaxation?
Yes, yes, and the single judge quotes that rule. Then most importantly, the single judge records instances of relaxation.
All right, let us see the rule. Yes, you had cited that. On the last occasion
I
also.
just wanted to show my lord. One thing else. Suppose Nagraj is not followed and that exercise is not done. Then most importantly, there is one judgment which the single judge also takes note is Ajit Singh Januja 1. Those two paragraphs I just need to show. It's a part of my additional note at flag G. Because that judgment actually may be the crux of the present case. I need to just show two paragraphs. Now that's flag G of that compilation and Ajit Singh Januja 1 that begins at page 10 of that compilation at flag G. Now, the moment the exercise in terms of Nagraj is not done, then we have to fall back on the law prior to Nagraj, and Ajit Singh Januja still holds the field. Now, my lord may just see what Ajit Singh Januja holds in paragraph 15. The judgment is at page 10 of that compilation at flag G. Additional note.
Yes.
And the judgment Ajit Singh Januja, my lord, begins from page 10 and the relevant paragraph is at page 28. Paragraph 15. I hope my lord gets that paragraph.
Yes, sir. Yes.
Now, paragraph 15, they discuss about this reverse discrimination. Since I'm short of time, my lords, may I just take my lords to the next page, just above paragraph 16, towards the middle. Even where the process of promotion by selection is adopted, seniority has an importance in case of equal merit. The principal object of a promotion system is to secure the best possible incumbents for the higher position while maintaining the morale of the whole organization. The best public interest is served when equal opportunities for promotion exist for all qualified employees. Civil servants are able to move up the promotion ladder as the merit deserves and the vacancies occur. To equality, enshrined in the Constitution, is to be preserved by preventing reverse discrimination as well. Now, the next line, my lords, is very important. The guarantee of equality requires maintenance of original or panel inter se seniority between the general category candidate and the earlier promoted reserve category candidate under reservation policy for promotion to the higher general vacancy. The equality principle requires exclusion of the factor of extra weightage of earlier promotion to a reserved category candidate because of reservation alone when he competes for further promotion to a general category with a general category candidate senior to him in the panel. Any other view would amount to reverse discrimination and violative of the guarantee of equality under Articles 14 and 16. Then paragraph 16, we respectfully concur with the view of Union of India versus Vipal Singh Chauhan that seniority between the reserve category candidates and the general candidates in the promoted category shall continue to be governed by their panel position, that is with reference to their inter se seniority in the lower grade. The rule of reservation gives accelerated promotion, but it does not give the accelerated consequential seniority. If your scheduled caste / scheduled tribe candidate is promoted earlier because of the rule of reservation roster and his senior belonging to the general category is promoted later to that higher grade, the general category candidate shall regain his seniority over such earlier promoted scheduled caste, scheduled tribe candidate. As already pointed out above, that when a scheduled caste / tribe candidate is promoted earlier by applying the rule of reservation / roster candidate is against a post reserved for such scheduled caste, scheduled tribe candidate, in this process, he does not supersede his seniors belonging to the general category. In this process, there is no occasion to examine the merit of such scheduled caste, scheduled tribe candidate. As such, it will be only rational, just proper to hold that when the general category candidate is promoted later from the lower grade to the higher grade, he will be considered senior to the candidate belonging to the scheduled caste, scheduled tribe who had been given accelerated promotion against the reserved post for him. Whenever a question arises for filling up a post of scheduled caste, scheduled tribe candidate is still higher grade, then such candidate belonging to scheduled caste, scheduled tribe shall be promoted first. This is important. So here ACF was a reserve post. Now DCF, they are not, it's not a reserve post. Now both are competing on merits. Both are, there's no reservation being applied. The Honorable Single Judge takes note of that. So here this later portion would apply. Whenever a question arises for filling up a post reserved for scheduled caste, scheduled tribe candidate in a still higher grade from such candidate belonging to scheduled caste, scheduled tribe shall be promoted first. But when the consideration is in respect of promotion against the general category post in a still higher grade, then the general category candidate who has been promoted later shall be considered senior and his case shall be considered first. So this is what we are banking upon.
Considered first if
the rules, then my lord would come to the rule. So now here, my lords, the question is, we have a Supreme Court judgment and we have 309 rules staring at each other. What the Honorable Single Judge has done, he has tried to balance it out. My lords, I get the point, my lords, that whether the Single Judge could have done this in view of this. Not, first of all, we have sat over our rights. We didn't come immediately to court. That's a point against my clients. I bow down to that. There, I would again try to persuade your lordship with a Supreme Court judgment, a 5-judge bench judgment, which says that if there is a violation of 14 and 16, this delay and laches may not always stare at the court. That judgment I have given, my lords. It's a part of this compilation, just to persuade your lordship. But then there are judgments against me also. I have to concede that. Particularly judgments coming now from the Honorable Supreme Court, they say that 1 year, 2 years, 3 years, those timelines have been framed. I cannot meet that point, that stares against. So what I would try to submit, my lords, is the Single Judge, those paragraphs, if I can show from the impugned judgment. I'm sorry, my lords, your lordship wanted to see that. I just took my lords to this Ajit Singh Januja.
No, I just wanted to again see that, the rule, which provides for relaxation.
Part of the judgment. In the judgment, the court has taken note of.
Still, we would like to see the rules.
The entire rule will also, we have filed. Repressions. Yes.
So that would be at page. It would be Honorable Single Judge. My lord, may kindly see page. Page 58. 58, paragraph 21 of the impugned judgment.
No, my lord wanted to see the entire rules.
That is my defect.
Yes.
I cannot understand statutory provisions unless I read them as they are.
You will make it. We'll make it.
Your lordship, it is annexure 4 to the writ petition, your lordship. Page 57 to 63 of the writ petition. Yes, 6/7/2015 notification, annexure 4 to the writ petition.
In the notes of submission also.
Notes also have to be.
Manan Senior has annexed the entire rule.
Entire rule. Also stated as in
page 19 to 25.
Page 6 to 15.
No. Page 19 to 25.
I'm sorry, 19. You are correct.
Which page of the writ petition?
Writ petition, your lordship, page 57. 57.
And the eligibility criteria is at page 58.
Yes.
Rule 5.
And also it is in page 19 of our notes and submissions.
And where is the relaxation clause?
That is at page 61. If my lord is holding the writ petition, it is at page 61, clause 14.
Miscellaneous, part 5 miscellaneous. Yes, public interest. And from, yes, Public Service Commission. Correct.
But this power can be exercised only in consultation with the
yes,
Commission. Orissa Public Service Commission. All right.
And the instances where we had given that the single judge also records, there were certain instances given in the writ petition itself where they had relaxed 4 years, 2.5 years. And here all the relaxation that has been applied would be in the range of say 1 year. So there were instances where this relaxation had been applied. The writ petition, the petitioners did bring that on.
So as on date, none of you are aggrieved by the decision of the government.
Except we 5, your lordship.
Huh?
Except we 5, your lordship.
Except you 5.
Only 5.
If
5
your
of the
cases
appellant.
are also.
Appellants, your lordship.
If your cases are also considered, then
yes.
In fact, they are eligible, my lord, because
No,
5 posts
they
are
are
kept
eligible,
vacant.
the posts are probably lying vacant.
5
whole
posts
thing
are
is that
kept vacant for them.
There may be, I don't know whether they have considered in DPC of 2024, but 2023, if they are considered, we have been considered and we have been found suitable and eligible. But we have not been given the appointment. That is our only case.
And this would stare at me. What falls from the court is that relaxation, whether it could have been directed in this manner, but there just to persuade your lordship, there's one judgment which I have tried to bring in.
No, but instead of direction, we can ask them to consider.
My lord.
This can be done. We will see. We don't know.
As
We
such,
have not made up our mind.
There would be one issue that even if they are considered now, their seniority, the only thing this now boils down to is seniority.
No.
Whether they would be senior to us or whether we would be senior.
Yes.
Ultimately, it's a question of senior. So, and now I'm told that there are vacancies. So they can be promoted. Who would be senior? It would be the only thing that has to be done.
That will depend on my lord's adjudication. If 23 DPC is held to be valid, if my lord directs the 23 DPC to go ahead, then these persons become senior. If 24 DPC is valid, and as we have already conducted, all of them have been promoted, and those 5 will be also promoted. Because
No, even if these 5 persons are promoted on the basis of 24 DPC,
my lord,
then they will be above them.
No, because by rank, original rank, they are senior.
Catch-up formula.
Original rank,
will
these
not
people.
be above them, yours. Never.
Original
You will not
rank,
be above them. Okay.
because my lord, original,
My
the entry cadre,
observation-
they are senior.
I'll simplify this, even though it goes against me. If your lordships completely negates the order of the honorable single judge, then my learned seniors clients would be above me because then they would be eligible on that date. We were not eligible. So if the honorable single judge's order is completely reversed, then my learned seniors clients would be senior because on that date we were not eligible. And then there has to be a specific direction that you implement 23's DPC first, and thereafter you can do whatever you want. If those kind of directions come in, then my learned seniors, because obviously they would be senior to us.
No, such a situation will not arise now.
No, the observation was different. So if only 24 DPC, if their cases are also to be considered with 24 DPC, then they will not be senior to you. Then
we cannot be senior.
Seniority will,
We cannot be senior lordship. To them, we cannot be senior lordship because they will be maintaining that seniority list which is continued, your lordship. But here, what has happened, your lordship, as it appears, as we have already told also, that our names are placed much below the other persons who have now come up above us, your lordship. That is why our apprehension is that if 24 alone is to be considered, then we 5 may not get the promotion, even though 5 persons are vacant also. But if 23 is taken into consideration, and 23, because out of us, 15 have already got, your lordship, out of our opposite parties in the writ petition. 15 have already got the promotion, and we have 5 only are left out, Your Lordship. And prior to us, and if 15 are taken over to that 23 DPC, because that position has not come out as on date, Your Lordship, subject to Your Lordship's direction only it will come.
No, but you also admit
My Lord.
that your promotion was contrary to the law laid down in Nagraj.
No. No matters. Because that situation never arose, Your Lordship. Because they have never challenged that.
No,
which
forget challenge. Forget challenge. You were granted promotion based on reservation. This is a fact or not?
Yes. Earlier, yes.
Earlier,
SCF, yes.
Earlier, you were
SCF,
granted promotion
yes.
illegally contrary to Nagraj.
Well, then that situation never came up, so that those words I cannot admit nor can I.
Something which was illegal 20 years back is illegal even today.
No,
it's a different matter as to how the rights of the respective parties are.
That has been set right by the senior list being corrected, Your Lordship.
Very difficult.
Yes. That has been set right on 9/9/2022. 9/9/2022, the senior list has settled everything. That's the issue has been settled, Your Lordship, once for all.
And that is the reason why possibly the state should consider relaxing that, invoke that relaxing clause. Relaxation clause.
Your Lordship, I'll just add here, Your Lordship. Relaxation issue was only available till 31st December 2023. In respect of the writ petitioners, Your Lordship. Thereafter, it doesn't appear here. It doesn't occur, Your Lordship. Because that is why the alternative directions have been given by the Honorable Single Judge. Because had they been considered in 2023, then only Rule 14 was relevant, Your Lordship. Because now they being considered in 2024, the relaxation clause.
Now they have been considered in 2024 because they could not be considered in 2023.
Yes.
So in 2023, they could not be considered because they had not completed
the
that
eligibility
period.
criteria.
So they had a relaxation been granted to them in the background of the illegality meted out to them because of violation of Nagraj. Probably they could have.
My Lord, I have gone through that their counter, Your Lordship, and the submissions also. There they say that the public interest or never demanded the relaxation clause to be applied, Your Lordship. That is their counter, Your Lordship, government's counter.
That is their counter.
That is their counter. And this particular issue, they have said that we have done in right earnest, we have done, who have been eligible, we have taken them into consideration. 1/1/2023.
We will see.
That is required. And Justice, Your Lordship's predecessor has one decision also on this aspect, Your Lordship, which we have also given in my note, Your Lordship.
Yes.
That is 15/11/2022. It is at page 60 of my note, Your Lordship. I'm not taking attention.
Yes.
Yes.
Page
17, page 76, Your Lordship, of that note.
Submission.
Notes on submission, Your Lordship. We have flag Y, Your Lordship.
Flag Y.
Flag Y. 60. The judgment starts from page 60, Your Lordship.
कौन है ये?
Flag Y.
Last document.
Flag Y को देख लीजिए.
Last.
I think it is digitalized. Is Your Lordship handle tables?
Last five.
Not yet. Hard copy दे दूँ ना.
Yes.
Lordship, may I take Your Lordship to page, running page 76 and internal page 17 of the judgment.
Which one?
Whether the para 30, Your Lordship, whether the relaxation in the period of residency in the feeder camp.
Oh, writ petition. I have opened writ petition.
Just a minute.
My
Which one? Additional notes.
notes and submission, Your Lordship.
Yes. Yes.
My Lordship, I'm referring to para 30, Your Lordship, internal page 17 of the judgment. And continuous page is 76, Your Lordship.
Yes.
In response, whether the relaxation in the period of residency in the feeder cadre will affect the promotional prospect of the petitioner. In response to this question, we clarify that the candidates who will come within the zone of consideration for relaxation will only be considered after the candidates who are within the zone of consideration without relaxation in the residency period in the feeder point are considered. Hence, there shall not be any common zone of consideration for consideration of promotion to the post of superintendent of jail after the relaxation in the residency period. So here, Your Lordship, my submission will be that even if the relaxation clause is to be applied also, they have to be taken in below us, Your Lordship, as 2023 is to be taken into consideration, Your Lordship. Because we have been found, prima facie, we have been found to be eligible, and following Rule 5 of the Rule 15 rules, we have found eligible, Your Lordship. So relaxation question will come later, Your Lordship. 14, if that is there, Lordship. And by applying the relaxation, they will not come up above us, Your Lordship. And in that position, with that observation, I am submitting, Your Lordship. If 2023 DPC is also to be protected, and the orders which are to be passed also pursuant to 2023, if they are passed on the same day or with the same date, or it will take effect, then also that will serve the purpose also. That will not injure anybody. And here, why I am saying that I cannot be considered, because they have already stated in this appeal that the appellant's name, they stand at the serial numbers. Yes. Yes. They start from serial number 50 to 62, my notes.
Already we will see. We have
Yes,
understood.
that there is. Which one?
Order is
Yes. And my lord, my learned friend cited that Ajit Singh Juneja, Your Lordship. Januja 1, Your Lordship. And I'm very thankful to him because he has also submitted the Januja 2 judgment also. There are two paragraphs I will only point out to Your Lordship, which is there. It is at page 233 of his note, Your Lordship. That much, 233, page 233. And para 84 and 85 of the 1999 judgment, Your Lordship. He is referring to 1996. And this is the subsequent judgment, 1999, Your Lordship. Page 84 and 85 at page 233, Your Lordship.
Yes.
There, Your Lordship, the situation has been, there have been 4 levels of posts, Your Lordship. And here in this case, there are only 3 levels, Your Lordship. Your Lordship says, sees at page 80, para 84. Before we leave, even if seniority of roster point promotees does not count, experience of both groups can be considered as part of merit for further promotion. Before we leave point number 3, you may refer to another submission made by Shri K. Parasaran. Senior
which page you are reading?
My Lordship, it is 233 of their note, Your Lordship. My learned friend's note, Your Lordship. And it is 1999 7 SCC, page 248. My learned friend's initial note, which is flag X. Flag X.
Yes, 234.
233 and 234. 233,
Yes.
I'm referring to 233 here also.
Yes.
Para 84 and 85. Before we leave point 3, we may refer to another submission made by Sri K. Parasaran, learned senior counsel for the reserve candidates. Learned counsel submitted that even if the seniority of the reserve candidates had gone up to level 3 earlier, by the roster at 2 levels 1 and 2 is not counted, still the experience gained by them at level 3, well before the general candidate, senior general candidate caught up to that level, cannot be disregarded for purposes of promotion to level 4. It is true that the roster point promotee who has reached the promotion on level 3, even if he is not entitled to seniority, would have gained considerable experience at that level. That experience is no doubt of considerable relevance in considering his case for further promotion to level 4. But at the same time, it is to be noted that the general candidates had longer experience at level 1 and level 2 and have come up to level 3 by way of competition among the general candidates at 2 stages. They said longer experience gained by them at lower levels 1 and 2, and in which and the manner in which they have reached to level 3 to which the reserve candidate had reached earlier are also relevant factors. The quality of the experience of these groups also needs to be kept in view. The above principle would be an equitable balancing of the experience of the candidates at various levels. It would be appropriate for the government of India and the state government, as the case may be, to formulate guidelines by way of administrative orders or by way of rules in this behalf. Point number 3 is disposed of accordingly. Here, Your Lordship, I will submit that in accordance or to alleviate this particular situation, this 2015 rules has been formulated by the government, Your Lordship. And the terms and conditions or provisions being specific, Your Lordship, it has to be abided by in true letter and spirit, Your Lordship. That will be my humble concept. I leave it to Your Lordship. Because I don't want to take further time by referring to the judgments which we have cited. Since I will just pray before Your Lordship to file the judgment, Your Lordship may kindly have a look at the judgments, because I have indicated that in my notes also. Very grateful. Grateful.
We are all grateful.
Grateful.
Note 25. Also directed me to produce the gazette notification. Yes.
Yes.
That gazette notification, the 33(3) of the Orissa Cooperative Act has not been brought by way of amendment, as has been referred in all the books, my lord. And previous 33B has not been deleted also. Previously 33B was there prior to this 27/12/2004. Your lordship kind come to this gazette notification. The book your lordship referring, the 33B, the power has been vested according to this 33B with the register to frame the rules for common cadre of the employees of PACs, LAMPs, and other primary cooperative societies.
Which section?
33B, section 33B. And all previous groups have also referred that to Notification Act 11 of 2004.
But how come this has, I think some other reference may be there. This footnote number may be wrong.
The footnote number, other publication books are there.
No, I'm not on that.
I have got other publications.
Text has been lifted from some other gazette, maybe some other act. Do you have any?
My lord, actually I had sought for instruction on this because last
No,
day
no.
on the.
He has produced this gazette.
My lord.
what it emanates from this gazette that Amendment Act 2004
No, no.
does not contain this insertion
Exactly.
of this provision 33B.
33B.
So if this text is there in the some
Yes, sir.
textbooks,
My lord,
from somewhere they must have.
I have verified that the notification published in the journals from 2004 to till date, my lord. I did not get it. I got this Act 24, Act 11 2004 from the Orissa Law Review for Publications also. But thereafter I verified myself. I could not get this text by way of other amendments. 2013 amendments were there and other amendments were there. And this provision, my lord, that the cadre itself, that what the contents is there, the rules frame that is contrary to section 28 also. Rule what has been framed, that is contrary to the section 48. 28 clause 28.
So how should we read it then? 32, 33B we cannot read?
No, can't be.
33B cannot be read.
Cannot be read. My lord, your lordship may direct that the Cooperation Department that from which these contents have been brought, my lord, in the book, my lord. Whether these contents.
The state government is not the publisher.
No, whether this, I am not my problem. I am not saying my
Therefore, if something has been done by the publisher, what can be done?
My lord, I may be wrong, my lord, I may say I may be wrong whether these contents is there because the registrar has exercised that power by framing the rule, my lord. 33B. Your lordship kindly come to.
No, but see, this refers to Act 11 of 2004. We have Act 11 of
yes, fine.
2004.
But I am referring to the section annexure 5, my lord. That there the registrar has exercised the power on the 33B, my lord. Previously 33B was, my lord, I am taking to lordship what the.
Do you have any instruction?
Actually, I have not received the instruction, ma'am.
Very bad.
No, I'm, my apology, my lord.
It's impossible for the court to decide then.
Previously 33B was there, my lord, placing that 33B previously.
33B?
That was previously. That was the, my lord, that was brought by Act of 28 of 1991. There it has been provided the functions of apex and central societies in respect of affiliated societies. An apex or a central society shall perform inter alia such functions in respect of the society or societies affiliated to it as
What
may
are
be
you reading?
prescribed.
What are you reading?
Well, that previously 33.
So what should we do with that?
No, that was there. That has also not been repealed, my lord, or has not been substituted.
So there is, if we go by this publication, it says amended by Odisha Act.
That is not there.
Not substitution.
That is not there. I have brought that.
Second substituted by Odisha Act 19.
And another my recent
May I submit, ma'am? May I submit? My lord, may give me 2 weeks time, finally, last chance.
Please find out. It's a serious matter. Otherwise, whether there is any section like section 33B or not.
My lord, another 2007 publication is there. There, this provision is not there.
Not there.
So we cannot decide by cases by publications, private publications.
Let them take instruction, my lord, whether that provision is there or not in the.
The same thing. Indian Canon shows amended by Odisha Act of 11 of 2000. Somewhere it is.
All refer to that, my lord, that has been deleted.
It must have been one publisher must have got it from some gazette.
Yes.
So that noting by the publisher may be
My lord,
printing error.
giving other publications work also to your office, my lord. Same latest.
One mistake perpetuated by all. Even
all
Indian Canon is
publishers,
also making the same mistake.
All publishers, my lord. My lord, while conducting a case, my lord, regarding the municipal act, my lord, Municipal Act regarding that Atmalik NAC, my lord, that the wording was not correct in the book, my lord. Either that cannot be the language of the statute. I wanted to know that from which book I can get. That is local law published by the former judge, Justice P.K. Mahanti, Prafullo Kumar Mahanti. Because the Honorable Justice Prafullo Kumar was very meticulous, my lord. In his book, it must be the language must be different. I brought that book from the one senior office, my lord, and found that the language is completely different. But I was thinking, well, that was the language of that statute. You'll also direct the state government because it's important. It will affect number of persons of the societies, employees of the cooperative society, primary society throughout the state. That rule has been framed by exercising that power. What language has been stated in that book, my publishers, that power has been exercised by the registrar, and this rule has been framed under Annexure 5, which I am challenging.
May I please, my lord, may kindly direct the registrar cooperative society to file an affidavit within a period of 3 weeks so that I can comply.
From where that power has been brought by the registrar.
Annexure 5 is in English or Hindi? Annexure 5. The Office of the Registrar of Cooperative Societies, Odisha, has issued an order wide number 9583 dated 25/2023 in exercise of the powers conferred upon him under section 33 capital B of the Odisha Cooperative Societies Act 1962, prescribing the rules called quote, the common cadre of chief executive officers of PACS, SCS, LAMPCS and FSCS rules, 2023. Full stop. Section 33 capital B of the Act as mentioned in an OLR publication of 2024.
33B has been inserted by Odisha Act 19 of 1983.
Yes, this is what I was saying.
That is language all 83 is completely different.
That is rcs.odisha.nac.in.
My lord, you will also kindly see.
Now please come to the book.
Yes.
Please come to the book.
Yes.
And see the second part at the bottom. Second note.
Yes.
What is that?
Amended by Odisha Act 11 of 2004.
No, next to that.
Substituted by Odisha Act 19 of 1983.
So this is the provision by which
34, section 34.
That is wrong noting, sir. Somewhere printing mistake has.
83 prior to 91, my lord. That was the
RCS website shows this, sir. The substituted by Odisha Act 19 of 1983.
83. That
had you got the Gazette of 1983, you would have got this
My lord,
clear picture of
my lord,
this
I have brought
33.
the books of, my lord, same publication.
Maybe, sir, there may be printing error, but we have to
No, my
go to
lord,
the
kindly hear
proper.
me for a moment. Kindly hear me for a moment, my lord. Here, my lord, I have brought the book of 2002 publication, my lord.
I can understand. Maybe. He's trying to appreciate.
Yes, yes,
We have been able to find out,
yes,
substituted by an amendment of 1983,
83.
reference of which finds place in that book, in the new book also,
Yes.
but wrongly. It has wrongly been mentioned as something else.
I understood, my lord. I
Mr.
understood
Mahanti,
what you lost.
Mr. Mahanti, I am on a book published by Government of Odisha, Law Department,
Yes.
corrected up to 31st December 2005.
Yes,
That book is available in the website,
yes.
in the Registrar of Cooperative Societies Odisha web portal itself.
Yes.
Right?
Yes.
There, this book shows 33B has been inserted by virtue of Odisha Act 1983.
83, my lord.
Had you got that Odisha Act 19 of 1983, that gazette, you would have got the clear picture that 33A.
My lord, I verify, my lord, but what my humble submission before lordship, my lord, that prior to this, my lord, which has been introduced, prior to that, 33 was functions of apex and central society in respective affiliated societies. If it had been introduced in the year 1983, that 33B was providing the chapter that functions of apex and central society in respective to affiliated societies, my lord. You'll also kindly see this book also.
My lord, what my lord senior is saying that 33B was there, amendment.
It was there,
It doesn't
amended
provide,
time to time.
but it doesn't provide this, what rule giving power.
This is substituted subsequently.
Yes, yes. He's saying it is there, but it doesn't give rule making power.
Let my lord, let the registrar find it.
Refers to the Odisha Cooperative Societies Amendment Act 2004. Bracketed Odisha Act 11 of 2004. Petitioner has produced before us the Odisha Gazette published under the authority on 27/12/2004.
2004.
From which for the said amending act does not refer at all to section 33 capital B of the act. First of let the registrar of Cooperative Societies Odisha file an affidavit stating clearly the history of section 33 capital B of the act in the present form. For the said purpose, the matter is adjourned to
Fix a date one.
So when you know, it's one challenge. Yes.
Man, give me.
Page 1.
Your Lordship, exit. Man, go bless.
Item number 26.
The petitioners
served a copy of rejoinder. I'll take instruction on that. Your Lordship may call this matter next week any day.
New fact has been brought up.
Yes, ma'am. That's they have stated in that rejoinder. So only they have challenged the virus of the rule. So in that rejoinder, they have taken the stand. So far as relaxation is concerned, so they have fixed a cut-off date. By that date, state government has the only authority to grant relaxation. Only in respect of that, what was the cut-off date? I will take instruction at that short point only.
Item number 27.
In that 26, three matters are there. In one matter, I have filed counter. In other two matters, I am adopting the same counter.
My lord, in that case, my lord, there is a noting that the copy of the rejoinder not received, but in fact, I have filed it on the and also there is also a noting that the government council has filed a counter. Second copy has not filed.
Second copy is doctor
My lord, second item in 26 is separate, my lord, because I have made a party to NCT, my lord. NCT to file the counter.
Yes. In all the matters relating to that virus of the 2019 rule.
Still, my lord, there is a since the matter is rule is framed by the government of India, so NCT is a party, and NCT have to file the counter, my lord.
Yes, that's no, it is. I don't.
This case may be segregated. But
your case may be segregated.
Yes. Number of copies you have to serve.
Yes, I'll serve.
You have challenged what?
Virus, I have challenged the virus. As because the state government violated the rule of government of India, as framed by the Minister of Education, since I made the party to NCT and as well as the Secretary MHRD, my lord.
You are opposite party.
No, my lord. I am the petitioner, my lord. My lord.
You are challenging the validity of statutory provision.
My lord.
And you also want someone to be treated as party.
Party, government of
The
India.
order has been violated.
My lord.
his case may be segregated. May I pray one thing, my lord? My lord, I call this, my lords have directed to list this matter 2 weeks after. May I pray, my lord, I call this matter first week of April? Because in the meantime, during the pendency of this case, now they are going on promoting the
Code of
others.
conduct is.
So that is the problem. May I pray?
They are not promoting any of
my lord,
within
may
2
I
weeks.
have already given also.
Taken note of if they are not going to give promotion,
Yes.
contravention of that rule. Well, then we have nothing to say. Well, central government rule makes it clear that academic qualification, training qualification plus OTT pass is the essential qualification for the post and to get promoted.
Which post?
From the post of assistant teacher in level V to level A to level B and level B to level 4, level 3 onwards. Well, 5 levels. Rule 3 of the elementary cadre rule of the state constitute 5 cadre.
Best level
From level VA to level 1. That what happened? The Central Government Act, RCFC Act, Section 23, makes it clear by way of amendment in the year of 2017 that the relaxation so far to the acquisition of OTT qualification is to be made at best by 1st April 2019. By giving further 4 years relaxation
in addition to the earlier 5 years relaxation. And accordingly, the NCT also framed the rule of the 2014 that the qualification prescribed by the NCT, which is the prescribed authority, that is to be added to for promotion from one level to another level. And that is available in the third case, that the entire notification I have given. Now, what the government did, my lord, after expiry of the term of the relaxation, the state government brought an amendment bringing that OTT pass is to be absolutely exempted for the teachers those who are recruited prior to that, which is contrary to section 23 read with the rules of the RCFC rules. Therefore, it is what they are doing, my lord. Even teachers, we are the petitioners, even having from the beginning with these 3 qualifications, academic qualification, training qualification, and OTT pass qualification, we are not getting promotions, but the teachers not having OTT qualification, in contravention with that, my lord, they are going to get the promotions.
We are ready. We don't have any.
Yes, sir.
We are ready.
Yes.
Yes, my lord.
While-
Conflict in state law and
Yes.
state central law, 254 article, my lord.
While issuing notice, your lordship has directed that will be any promotion will be subject to outcome of the case. Yes, but
I am ready, my lord. Your lordship may call this matter on Friday. I am also ready. I will take instruction within 1 day.
Yes.
So I am praying. Why they are
Let it come any day, your lordship will be the only point of law.
yes, yes.
Your lordship take it next week. Well,
Item number 27.
My decision PIL, my lord. My decision PIL, my lord. The public of Badkur, after formation of GP, they have suffered a lot due to the revenue inspector office for Tahsil work and the revenue work. They have requested to the government for a new circle office in their GP. Accordingly, I see for the moment page 68. Page 68. The government, after considering the grievance,
questioning the decision of the state government for the section of what is RL?
Revenue Inspector
Office. Revenue Inspector Office. And Assam
at Badkur.
Balipur.
Badkur.
Badapur Assam.
Ashram Balikuda.
Balipur.
Balikuda.
Balikuda instead of Badakula. The petitioner asserts that the said decision has that the state authorities have deviated from their previous proposal as proposal to stop. Earlier, RI office was proposed to be located at Badakula. Next. In our considered opinion, in a proceeding of judicial review in exercise of power under Article 226 of the Constitution of India, this court is not supposed to enter into such disputes which are primarily of executive nature. So we do not find any merit in this writ application, which is accordingly.
Malad, I may be allowed 1 minute. Malad. I may be allowed to say 1 minute. Malad. On 4/8/2022, the government decided to formation of a new RI circle at Badkur. That is page 68. Accordingly, tender notice was issued for Badkur. But deviating the government direction, the Tahsildar has shifted the place to Ashram Badkur. I have challenged that inaction of the Tahsildar. Government directed for Badkur, tender notice is issued for Badkur, but work started at Ashram Balikuda. And the Bodkul, the middle place in the GP headquarters.
And that work has already been progressed substantially. I am for the interveners. The work has already progressed substantially. So
Item number 28.
In item 28, my lord, they have challenged a resolution solely on the ground that there was no rule. But in the meantime, we have framed a rule so that this petition has become infructuous.
Lordship, I have filed an amendment petition.
Amendment challenging the virus of in the amendment.
In the meantime, the resolution has become the rules.
That is a separate fall of action. The council can challenge you.
Yes.
That's why I want to incorporate the amendment.
Separate fall of action.
And this notification also comes prospectively from the date of gazette.
Yes.
That's right.
Lordship, I gave me the liberty to file.
Hospital Association. File the present rate application. Seeking watching of resolution dated 8/6/2023. That was regarding what?
That is a resolution fixing that cadre of excise constables. So they said because there is no rule, so by virtue of that resolution, they cannot say that the excise constables belong to district state cadre. In the meantime, that rule has come.
may I, of course, I am for the interveners. Though resolution was challenged, and the challenge was that there cannot be any, so far the originally in the rule under 2011 rule, that it is a divisional cadre, district cadre.
District cadre.
Now by virtue of this resolution, they made it a divisional cadre. Divisional cadre. Now you have passed for the interim order, not only on the ground of resolution, you can't alter and change since the rule is there. Now the rule has come. So far as this, or if my non-friend will not press this amendment application, then it will be heard by the single judge. So the interim order has been passed by the single judge.
No,
division bench.
Division bench.
Resolution was challenged.
Virus challenge actually division bench. Division bench.
Then in that case, my non-friend.
Yes.
And according to the association, we said resolution contravene the Odisha Lower Excise Service method of recruitment and condition of service rules 2011.
Yes.
So, next.
Lordship, give me liberty to file the.
Counsel for the petitioner after some argument seeks permission to withdraw this application with a liberty to question the validity of
The rule I have given that copy.
validity of
Odisha Lower Excise Service method of
validity of Odisha Lower Excise method of recruitment and conditions of service of excise constable bracket clause rules 2026. So this application is permitted to be withdrawn and stands disposed of with the liberty of
interim order granted.
interim order and wicket.
Item 29.
This batch of cases will be now disposed of by virtue of your lordship earlier order. Passed on 4th minutes in WPC number 4152 of 2024 minutes.
Lord, I think my learned friend will agree with me that these batch of matters listed today and prayers made hearing. Lord, the points which I am trying to take before my lords, my lord, neither were raised there nor have been decided by my lords. So lordship may give us opportunity so that our clients will be satisfied that their points are raised and your lordship will decide.
So what happened?
That was the case where your lordship only dealt with the policy, excise policy 23-24 clause 4. Here is a case. Besides that policy, we have other prayers and other points, my lord. Lord,
In that policy that rural and
no license will be, no on-shop license will be granted in rural areas. That prayer, my lord, though it is here, but Lord, that is either your lordship has decided that we are definitely at a weaker side on that of that case, my lord. Either we are not pressing that prayer or that prayer will be covered by my lord's judgment. So far the other prayer and other points which I am trying to urge before my lords, neither are raised there nor are decided there. So kindly allow us to. Yes, my lord. There the policy was only the petition policy was challenged. Your lordship decided the validity of the policy. Rightly, my lord. I also will have to bow down before my lord's judgment, my lord, saying that your lordship judgment will definitely hold the fleet. Equally, my lord, we are also bound by my lord's judgment and we bow down before my lord's. But so far as the other prayer here and the point which I am trying to raise before my lords, kindly allow us to raise it, my lord.
No, we will allow.
Grateful.
What is
here, my lord, we are challenging, in fact, Annexure 2. Kindly see. Besides that policy, we are challenging Annexure 2. Page 47, lordship may kindly. Lord, your lordship may take the lead matter. Page 12, top, page 12 at the top, Lotus Restaurant, WPC 198. I have. Judgment. Either your lordship may permit us not to praise that prayer, or your lordship may say that the prayer is covered by your lordship judgment, whatever. That's right.
Senior counsel and learned counsel representing the petitioners in the written batch of writ applications, in the light of the division bench decision dated 4/3/2024, passed in WPC number 4152 of 2024, bracketed Lakshmi Priyakar versus State of Orissa and others, submit that this shall not be pressing to be released, seeking
setting aside of clause 4.2.3
on Roman 1.
Roman 1.
as far as the clause relief as against clause 4.2.3 bracketed Roman 1 of the excise policy of the state government.
Right.
Excise policy of the state.
Policy 23-24 were also there.
24.
State government. Excise policy. Orissa excise policy.
Yes, Orissa excise policy.
Orissa excise policy.
For the excise 23-24.
Excise policy for the year 2023-24. So, these have submit that there are other issues involved which they would address. So, yes.
That I have given a combined compilation for your lordship, kind assistance, my lord. Kindly take up that. Before that, I'll request my lords kindly turn to page 47 of my brief.
Which case?
My lord, this is WPC 19873 of 2023. The lead matter, page 12, my lord. Page 12 at the top. Page 12 of the list, my lord, of the cause list. Page 12 of the cause list.
Page 12 of the
cause list. The first matter in over this page, my lord.
Just 12 of the cause list, yes.
The first matter over this page, my lord. First matter, 19873 of 2023.
Lotus Restaurant.
Right. But I'll request this may be a lead matter for this whole issue. This may be taken up as the lead matter. So you see, Sir, this is 19873 of 2023.
Page 12 of this was top of the matter.
The matter appearing at the top of that page.
The Lotus restaurant.
Or maybe communication gap because of we use the draft list for your lordship is having the final list.
What was the case number?
Lord, that is WPC 19873
19873. We can find that.
of 23.
We can find that.
Right.
Yes.
Yes.
Lord, I request my lords to turn to page 47. The impugned order, only 3-line order.
Your first paragraph, first paragraph,
that's
first, that is all.
That is not pressed, my lord, in view of
Subsequent one.
subsequent paragraph. Rest of these,
Page 3, first paragraph.
Lordship is referring to the prayer.
No. Your petition, page 3, this is top.
That's right. I'm grateful. That's compilation.
So that is the second issue which you are raising.
Second and third issue. There are three pairs involved here. That policy part is one. 2 is the setting aside that order. Third is to consider us equal to that of 56 cases which you have already considered for that. But precisely I will be raising 2 points. One, there was an excise policy. I'm so sorry.
Yes, you are
right. There was an excise policy for the year 2022 and 23. 2022 and 23 excise policy, if your lordship could kindly turn to page 80. I'm sorry, my lord, I'm troubling my lords to page 80 of my brief, my lord. Page 80 of my brief. Lordship, page 80. 80. Clause 4.2.3. which provides for new on licenses to be granted, renewed in urban or rural areas, subs must adhere to basic infrastructure and hygiene requirement for consumer point of view. Then they have given the procedure. Now what I am trying to tell
2022,
23. Yes, sir. 2022-23 begins on 1/4/2022, ends 31st of March 2023.
That is the excise year.
That is the excise year. Now, what is the peculiarity here is, when this policy was, before expiry of this policy, lot many applications were filed for grant of on-stop licenses. Lot many applications were filed. Now, government, for its problem within itself, could not consider those applications, kept it pending for considerable period. Now, for that limited purpose, government extended this policy up to a particular period, more than 3 months of this policy. That your lordship will kindly see. That is at page 51. That is at page 51. But this is page 51 of my brief, annexure 3. That if your lordship would kindly take little pain to look at this small order I may be permitted to place it also. At page 51, annexure 3, extension of time for disposal of new on-sub proposals received during 22-23. I am directed to invite a reference to your letter, number so-and-so dated 13/3/23 on the subject cited above, and to say that 3 months further time beyond 31st of March 23 is permitted to process pending applications for sanction of on-sub licenses if the fee for the same has already been deposited during 22-23. Meaning thereby, this was extended for a period of 3 months, 27/3/23, and goes up to 26/6/2023. Am I clear, Mike?
Yes.
So 22-23 policy for the limited purpose of consideration of our application was extended up to 26/3/2020. I mean 26/6/2020. Now, my lords may kindly see our rejection order. That same annexure 2. The same annexure 2, page 47. That same annexure 2, page 47. During subsistence of that 3 months period, when 22-23 was very much applicable, they have rejected it, referring to 23-24 policy. Kindly see that, my lord. Page 47. My humble submission here is, when your policy 22-23, in your wisdom yourself, you have extended up to that period, 27/6/2023. You have rejected in 29/5/5/23 when 22-23 policy itself was made applicable for us by yourself. So you cannot take resort to 23-24 policy for rejection of our application. That too, within that extension period, you have rejected it. Am I clear now, man?
Oh, let us come to annexure 3 again.
Right, man. Annexure 3. Page 51. Right. May I be permitted to place it, man?
It says permitted to process pending application.
Right, Willard. Beyond the 31st of March 2023 is permitted to process pending applications for sanction of on-sub licenses if fees have been paid during 22-23. So it's a case we have paid our fees, our applications are pending, and for that limited purpose, you extended 22-23 policy for a period of 3 months. And this goes up to 26.
Any case.
Right, man.
But
I'll have a little submission there. Now, one more point. Now, 22-23, along with us, there are other applications. You merely allow 56 applications, list of which is available with my lords. Kindly see that.
22-23 or 23-24?
But they have given it 22-23, page 92. Merely you have allowed them. Even I have instruction that these applications are also allowed in 23. Some of these applications are allowed. I am yet to get those materials, my lord. Of course, I am yet to get those materials. But kindly see for the moment, page 92. Kindly see. All these new subs who are similarly placed and applicants along with us, you allowed them. So I have taken a ground of discrimination referring to Nandalal Jaiswal. But even if it's a trade relating to pernicious article, and no trader has fundamental right of carrying on this trade, but in Nandalal Jaiswal, principles of natural justice and discrimination is saved. If a lordship see kindly that judgment 82 Supreme Court, we are only limited to that extent only. State is not permitted to discriminate similarly placed persons who are claiming similarity on the basis of their applications. But Nandalal, along with my convenience compilation, I have given my law. Kindly see. Running page 41 of my convenience compilation. 41 starts from paragraph 33. Kindly see page 41 of my convenience compilation I have given. It starts from paragraph 33. But kindly see kindly turn to page 41, paragraph 33, last sentence. No one can claim. At the bottom of this page,
Yes.
No one can claim as against the state the right to carry on trade or business in liquor.
Paragraph?
paragraph 33, my lord. I'm placing a part of it only instead of not taking your lordship much time. Para 33, last line of page 41, I am reading from this. No one can claim. Last at the bottom only. No one can claim as against the state the right to carry on trade or business in liquor, and the state cannot be compelled to part with its exclusive right or privilege of manufacturing or selling liquor. But when the state decides to grant such right or privilege to others, the state cannot escape the rigor of Article 14. This is one.
Which one is already?
Lord, I'm sorry, Lord, I have not been able to take my lord to the proper page. If your lordship is seeing page.
Paragraph 33 you are reading.
Paragraph 33, the last line of this paragraph, my lord, of that page 41. No one. So let me place para 33 as a whole, my lord.
No one from here.
Yes, my lord. I'm sorry, I am inconvenienced, my lords, my lord. Page 41, para 33, that bottom.
Then page 42.
Right.
Yes.
The right to carry on trade or business in liquor, and the state cannot be compelled to part with its exclusive right or privilege of manufacturing or selling liquor. But when the state decides to grant such right or privilege to others, the state cannot escape the rigor of Article 14.
Okay.
Lord, next very genuine question came to my lord's mind, my your lordship. In fact, before I initiate this issue, your lordship asked me a very pertinent question. In any view of the matter, 22-23 is over. Lordship asked me one. But the right of a litigant.
Para 34 also you mean.
Should I place it, man?
Para 34.
Right. But while considering applicability of Article 14 in such a case, we must bear in mind that having regard to the nature of trade or business, the court would be slow to interfere with the policy laid down. Yes, my lord, policy your lordship has already determined. Right? It's with regard to policy. That Article 14 with regard to policy. We agree here.
Yes.
Then another factor was also, guiding factor was laid down.
Yes,
Court would, in view of the inherently pernicious nature of the commodity,
yes,
allow a large measure of
latitude. A large measure of latitude to the state government in determining policy or regulating manufacture trade in liquor. Moreover, grant of licenses for manufacture and sale of liquor would essentially be a matter of economic policy, where the court would hesitate to intervene and strike down what the state government has done, unless it appears to be plainly arbitrary, irrational, or malevolent.
Yes.
Article 14 is excluded from the purview of this pernicious trade. It is not only here. If your lordship see Harinara and Jaiswal 72 Supreme Court, that's a judgment clearly lays down the law that in this trade, violation of Article 14 cannot be a ground, but only exception, as I read to my lords, that when you are granting to similarly placed persons, you cannot discriminate others. That is what this.
You say that your case is similarly situated to.
With those 56 cases, my lord.
How?
But they are all applicants along with me in the same year.
Different also after whatever.
No, but these are all on subs.
That will depend on the.
If that would have been the case, if that cause would have been shown in the impugned order, that is one of my grounds also. The order doesn't show any reasons to that effect. Individual cases should have taken up. You should have assigned reason that on this ground you are rejecting it. But on what ground are you rejecting? You are rejecting referring to only 23, 24.
Because 4.2.3,
right, madam.
Roman 1, that makes some distinction with regard to urban area and
Rural.
rural area.
Your Lordship is asking about 23-24 or 22-24?
No, 23-24.
But that is urban area, they have allowed to open in some cases, rural complete prohibition. And your Lordship has upheld that. So,
But whether this, out of these 56 or whatsoever
Right.
persons who have been allowed licenses, whether they belong to rural area or urban area?
they are all rural areas.
Rural area. All rural.
Or
Yes, ma'am.
56.
Urban are also there, my lord. This is, my lord,
No,
22-23, there is no
this-
distinction.
See, page 92,
Right, my lord.
as it appears,
Right.
Balangir, Baleswar, Berhampur, Cuttack,
Yes.
Bhubaneswar,
Yes.
they are all urban areas only. Dhenkanal.
Lord, they are all district names, my lord. They are all district
For
names.
the
District.
district.
But shops are all in rural area.
Oh,
That is not given. Your Lordship, look at the heading.
Let file a counter that they have not given license in rural areas.
Your Lordship, look at status of on-sub, shifting, transfer, conversion of beer parlor, etc. for 2020. It doesn't say that for this year, not in rural area, this has been given. Also, it's an extract.
in 2022-23, there was no distinction.
There is no distinction, no provision.
Because there is no distinction, the
Let it pass.
they must have been given.
who have been granted?
Big part.
At least?
Page 92, my lord. Page 92, at least I have got list of 56, but my instruction is that beyond that also have been given. Many numbers have been given. If an instruction is sought for from the state in the shape of an affidavit, they can only disclose what.
Whether it will serve any purpose. It's already, what is the?
Rightly, my lord. I'll just explain that. I'll reply to.
That.
Right. Kindly see my compilation. Begra Singh I have relied upon, my lord. Begra Singh.
Yeah.
My lord, 55 of my compilation.
Okay.
55 of my compilation, my lord. This is with regard to a minor mineral issue where the plea was taken that since the year of that lease is over, no relief could be granted. But para 7 Honorable Supreme Court says, kindly see page 55, para 7. Begra Singh versus State of UP, my lord, starts from page 52. May we permit you to place it, my lord. Having heard learned counsel for the petitioner, as also the learned counsel for the state and private respondent who are satisfied that petition deserves to be allowed. The ordinary rule of litigation is that rights of the parties stands crystallized on the date of commencement of litigation, and right to relief should be decided by reference on the day on which the petitioner entered the portals of the court. A petitioner, though entitled to relief in law, may yet be denied relief in equity because of subsequent or intervening events, that is, the events between the commencement of litigation and date of decision. The relief to which the petitioner is held entitled may have been rendered redundant by lapse of time, or may have been rendered incapable of being granted by change in law. There may be other circumstances which render it inequitable to grant the petitioner any relief over the respondents, because the balance tilting against the petitioner on weighing inequities pitted against equities on the date of judgment. In fact, the first part will be in my favor. That your lordship will consider, Lord. That your lordship. But your lordship, here we have all approached before lapse of that policy, which was extension date. Before that, 26th of July 23, we have approached my lords, my lord, and our matters are pending here. They have accepted application fee of rupees nothing less than 1 lakh each from us. 1,10,000 from us, man. And they will, in their wisdom, sit over the matter. They will grant licenses, a batch of cases out of this, they will pick up and grant license.
My lord, in this case, I'm holding brief in two cases, my lord. With your lordship's kind permission, I may be permitted to supplement whatever my learned senior is submitting.
Which case?
My lord, this is WPC number 20345 of 2023. WPC number 20345 of 2023. It's sub-item number 45 of 2023.
Yes.
Yes, madam. My lord, your lordship would appreciate the fact that the grant of license or exclusive privilege, my lord, it is guided under the Orissa Excise Act. Yes, my lord.
Where it is, today is 18.
Yes, my lord.
So in any view of the matter, by the end of this month, nothing can be done. So what can the court grant?
My lord, I will respectfully submit that admittedly, my lord, I was an applicant for the policy 2022-23, my lord.
Everything admitted, but what relief can be granted to you?
My lord, relief in the sense, my lord, your lordship can direct a mandamus saying that the license has to be issued. With my respectful submission, I'll say.
Which period?
My lord, let it be prospectively, my lord.
Prospectively from which day?
From the date your lordship passes a judgment, my lord. My lord, why?
No,
my lord, why I'm saying, my lord, let me just address your lordship. Excise Act provides that license is to be issued in a particular manner. But there are a set of rules which has been framed under the Act. But for a moment, may I take my lord to the relevant rules, my lord? But how they've been sitting over the issue and allowed a part of people to get the license and denied me.
Counsel, rightly or wrongly.
Yes, my lord.
A division bench of this court has taken a decision. Okay. That is against you. So beyond that, the points which senior counsel has raised, do you have any other point?
Yes, my lord. I would just supplement that, my lord. Your lordship for a moment can have the excise rules, my lord. My lord, excise rules.
No, but before that, you will have to reply.
Yes, my lord.
What order the court can give you?
My lord, your lordship, my lord, so far as the impugned order is concerned, if my lord finds that the impugned order is illegal and arbitrary, that needs to be struck down. And subsequently, my lord, a direction can be issued to them to issue a license in my favor. That is my respectful submission. My lord, in case my...
In any case,
yes,
can the court issue a direction to the state to issue license?
My lord, my lord, Begraj Singh case would come to my aid because my rights stood crystallized on the very day when I approached this honorable court, my lord.
Mr. Counsel, I am again repeating the same thing. Can the court, exercising writ jurisdiction, direct the licensing authority to issue license?
But at least, my lord, they can take a decision on that, my lord.
They can take a
Decision on that.
This is the only direction.
Yes, ma'am. Yes, ma'am.
Court can.
Yes,
now
ma'am.
we are already in the cross-taking.
What is of
My lord, that's...
Futile exercise now.
My lord, with great respect, my lord, the excise rules provides that license, when the applications has to be issued by the licensing authority by 20th of October. May I just place those few relevant rules, my lord, for your lordship's kindly appreciation. Lordship would see. My lord, this is Rule 30 of the excise rules. It speaks about preparation of list of licenses proposed to be granted for the next period of settlement to be completed by 20th of October. My lord, so by 20th of October, my lord, the licenses list has to be prepared. My lord, subsequently.
Lord, I have one more alternate submission, my lord, if lordship permits me, my lord. Lord, there is one set of orders in case of a 1920 application. The similar submission was made that the year is over and you cannot grant the license. This honorable court having said that you having sat over the application for this period, you cannot take advantage of your own wrong, directed them to grant license for 2021. This is the similar order is here. It can come to our rescue, man. Can you see this? Kindly similar to para 8 of this order. Identical situation arose here. Application of 1920. Kindly see para 8, man.
This is perhaps
my lord, honorable Chief Justice, as his lordship was there, and justice.
Keeping in view the COVID pandemic situation.
No. 1920, 2021.
Take a final decision.
My lord, kindly see, my lord. Para 8. In view of the above submission, learned counsel for the petitioner, we are not inclined to hold that the writ petition has become infructuous. In any case, OP number 1, Principal Secretary to Government is yet to take a view on the application of the petitioner, including the question whether license for arms should be granted or not to the petitioner for the year 2021 instead of 1920. Accordingly, we dispose of the writ petition directing opinion to take a final decision on the application for the petitioner within up to 15 days from the date of order. Now, my lord, your lordship can come to the rescue of this petitioner saying that let them keep this, treat this application pending till they have their policy. Mr. D.K. Mahathir under additional government advocate for the state opposite party submit that the petitioner had applied for license for the year 1920, which in the meantime has expired. Therefore, the matter has become infructuous. Para 6.
That was different. Come to paragraph 8.
Right, Lord. In view of the above submissions of the counsel for the petitioner, we are not inclined to hold that the petition has become infructuous. So the writ petition was not made treated to be right, Lord. Right. In any case, the OP number 1, Principal Secretary to Government Excise Department had yet to take a view on the application of the petitioner, including on the question whether license IFL on-sub should be granted or not to the petitioner for the year 2021 instead of 1920.
Decision has been taken.
Beg pardon?
Here, decision has been taken.
But here, that in that light, they have not. They have simply dismissed it, referring to 23-24.
That has been appealed in order.
Only I'll request, my lord, if a direction can be given to the state, since they have considered a very many numbers of cases, to keep our application pending, because our 1,10,000 is gone. This is a non-refundable application. We have taken the calculated risk there. To treat our application pending, my lord, whenever they frame their policy, let them consider this. In only that saving, if it is done, my lord, it will be a great respite for these people. Of course, in the current year, but they have extended the policy for next 3 months.
Do your business during the this financial year?
Definitely not.
Not?
Definitely not.
Before the order was passed?
Before the elections.
Before the order
Right.
of the licensing authority rejecting your application
Right, my lord.
passed, did you
No.
continue with your?
No. These are all new applications.
New applications.
All our applications are new.
No, all the applications are not new.
All the
All
applications, all new applications.
All new. No, let me tell why these large number of applications. No, what is the background? What the state did is, state imposed huge MGQ in respect of IFL ops. And by virtue of lottery, which was conducted in 2021, large number of licenses lost their licenses in the lottery process. So what they did thereafter is they wanted to somehow or other survive by this, and they wanted to apply for on-subs, which was not restricted by them. So they all of them applied to have their at least on-sub, because huge investments were there, huge stakes were there, employees were there. So that these are all things to save them. They wanted to have on-subs and they applied for it. State has been selective in some cases rejected it referring to the policy. Not only we can pray, my lords, keep these applications pending so that
one more thing may I point out to lordships. Prior to this, the petitions which have been filed now before lordships, most of the petitions had approached this Honorable Court challenging the validity of the rejection. Then they had not challenged the rights of that policy. Your lordships, my Justice Ramani's party, all the writ applications were dismissed. Thereafter, fresh writ applications were again filed, challenging the rights of that policy.
With the liberty of the court, my lord.
We'll try to dispose it off on the next week.
in my lord's pleasure. Yes. It will again appear in the list, man. It will appear in the list for the purpose of judgment. Great.
Yeah. My lord.
The application fees varies from one exciser to another, my lord. So they have written
That
you forfeited.
application fees is not
refundable.
Not refundable.
So I think, my lord, by this process, there is a unjust enrichment.
No, that is the policy. It is not refundable.
No, but you are also not following the policy.
If it is rejected, then it is
No,
doing
once you have extended the period.
So that amount is always.
No, once you have extended the period
Yes.
and you have given it to some persons, you have considered for some persons and disallowed these persons, then they have not got any benefit. So you consider that.
In that case, lordship's observation will take
Because you
care.
have changed your policy.
No, that I understand. Now the new policy is already come.
10,000.
1,10,000. That your observation will consider.
My lord, one case, I was the arguing counsel, that is Pradyumna Kumar Mahapatra versus State of Orissa. This honorable court observed that whatever fees you have taken, you are bound to repay.
But that is a different nature of case. I was there for the government. That is a different nature of case with my learned friend, not this rejection of on-sub license. That is relating to blacklisting. Some shop rooms were closed due to illegal sale of liquor, and that was recalled, set aside by the High Court. That is why the honorable court said that it is wrong. This is not similar.
What comes to our mind is that once you have crossed that 31st March, you yourself
extended
the period for another 3 months. At your own
Yes, in their own.
at your own discretion, you have extended.
We consider that.
And you have considered certain dealers, certain applicants, leaving aside certain other persons.
There is another aspect. We are finding it difficult to consider their relief because of the lapse of time.
Bad time
loss. So for these reasons, we may consider.
Your lordship observed that, so of course, my learned friend,
whatever
said
thought from my
that
last
calculate the
that
risk.
will be enough for us.
That will not lost one.
Because everything is ready. Just you will have to, because
My lord, we consider
everything is ready, my lord. Only they have to give us the license. We have made investment. We have invested huge amount.
Once it is rejected.
Sorry. Process is completed.
Item number 30.
Great.
Item 30.
Yes.
Counter affidavit has been filed by the OP number 5.
On 10-1 also none appeared.
He is not appearing for last 2-3 days.
Today also there is no result about the house of the petitioner. The second consecutive day when despite repeated calls. The petitioner has made unrepresented. Application is accordingly dismissed. Not prosecuted.
May I request your lordship to note my name for opposite part number 5 in BFs.
Item 31.
T1, my lord, I'm appearing for the petitioner. And I'm filing my objections to the IA, which has been filed by the opposite parties for vacation of the interim stay, my lord. My lord,
Why are you filing here?
because for the past few days, the matter has been rolling over in the list. If you will file in the registry, then it may not be tagged up with the, for that purpose.
All right, what is the matter about?
In matter here, my lord, I am challenging the construction of the vending or the food zone. Construction of the vending zone, my lord, in between the town hall and the backside of the hostel, my lord, which is a connect median road to the parallel roads, my lord. On the ground that the same has been constructed on near the drain, making it impossible for the drain to.
This is public interest.
Yes, ma'am. This is a public interest litigation. This is a second round of litigation. Earlier, the petitioners approached this honorable court, and this honorable court has directed to approach the collector and the collector to take a decision. Pursuant to direction passed by this honorable court, the collector has rejected our petition, my lord. And challenging that rejection order, we have approached this honorable court, my lord, in the present. That is at page, my lord, 52, my lord. The rejection order, Annexer 14.
So you are challenging that order in public interest litigation?
Along with the construction of the, because that was the direction given by this honorable court to approach the.
So that you don't have any public interest in your mind. Some private interest is there.
No, man, it's not a private interest litigation, my lord. May I kindly have a glance at the photographs which I have annexed, enclosed to the, my lord, my objections, my lord. I have enclosed the photographs of the construction of the.
Why should we see? First, we should see your bona fides. Each and every application. Not public interest.
Yes, my lord, it is a public. My kindly for us for a minute, I glance at the photographs I have annexed to the objection, my lord. Well, it will be clear from that only itself. Well, earlier the previous collector and the executive officer of the municipality has directed for eviction and demolition of the small shop rooms and food trucks, which were at the same place. It was their functioning, their business for the photograph. The objection I have annexed the photographs, my lord. How it is violating the.
We are not going to believe on the photographs which were.
No, it was taken after the construction erection of the structures, my lord.
Yeah, no, every person may approach. You are not. You cannot take up such matters in public interest.
My lord, we are the residents of that area, my lord, and what they have done is they have constructed the structure in front of the exit gate of the town hall, which has been used by the Deogod residents for the purpose of all the customs functions, my lord, all the cultural programs. For that reason, also we have also challenged that.
The district magistrate is in a better position to understand.
The previous collector has issued an order for eviction and of all the roadside persons who were encroaching the roads by putting up small stalls and for the construction, for the purpose of their own business, my lord. For the purpose that the same shall be beautified and the same shall be utilized for the parking purpose for the public. Now what they have done, the present executive officer has issued an order for construction of the vending zones by raising structures just adjacent to the drain, encroaching half of the.
Against public interest.
No, our.
For public interest.
We are not opposing the construction.
You don't want that like area to be declared as a vending zone.
Yes.
That's what you want.
Not that area. Instead of that area, we want that that should be taken up in some other place. There are a lot of vacant lands, my lord, which
And
are.
where is your house located?
My house?
Huh?
Not my house. That is a town hall.
Your house.
My house, I am a resident of the Deoghar.
Same place.
Nearby place. They have erected the rules governing the fire safety. And moreover, another structure has been put on the backside of the hostel, which covers the windows of the hostel, my lord. From the photographs, it will be very clear, my lord, which are forwarded in the objection.
Come to paragraph 13. The counter affidavit.
Counter affidavit by
filed by executive officer, Deoghar municipality.
paragraph 15.
13. You have filed.
Yes. I have challenged his locus standi because he was the ex-chairman of the municipality. Whenever after he lost the elections, whenever there is any development work of the municipality, he comes up with a PIA. My lord, his organization, which he has written in 4.1 of his paragraph, your lordship may kindly see in the writ petition. With your lordship's permission, may I place that paragraph. The Jilla Nagarika Committee Deoghar is a social organization and has been formed to look after the betterment of the general public of Deoghar. The present petitioner is the president of the committee. No documents have been filed, madam. But I have placed on the record, which they have not refuted in their rejoinder, that he was the ex-chairman of Deoghar municipality and is a veteran litigant in stopping any development because now the against party is the chairman of the municipality. Because he lost elections, he has filed this PI. And we have followed every procedure of law as given by the government HUNUD department, which the government has given. Public advertisement was made, paper publication was made, tender was invited, tender was done as per the Mukta Yojana of the state government. So there is no violation as so ever by the municipality.
Or will report problem.
My lord, may kindly have a glance on that photographs only, my lord.
No.
My lord, because the photograph itself shows that they have covered the exit gate, my lord, and they have constructed adjacent to the.
Tomorrow will start report.
Hello. 43. That is a contempt matter. They already complied with it. I am fictional.
It is stated by the violation of for the constant applications. Since we carried out. Oh. We can then proceed and stop according.
I may be, pardon your worship, item 34. So, my apologies, Lordship, I didn't see.
Item number 39. The original writ application has come along with the contempt application, my lord. In the contempt, my lord, one of the contemptors had filed the counter affidavit. Well, I am filing, the rejoinder I am filing today, my lord. So maybe taken up tomorrow, my lord. The rejoinder may be not tagged onto the record. I am filing today itself.
Because that matter lordships wanted to take up the original writ application because lordships had had the contempt application and lordships observed my knowledge senior was also there. Observed that let the writ application be taken out dispose of lords. So
I don't stand in the way. He is correct. Let the application be disposed of. Writ application, my lord. The contempt will not go. If at all there is a contempt committed, it will remain as such, my lord. So my rejoinder in the contempt may be taken into record and the lordship might kindly dispose of the application.
So let it be next week.
And this is my 9th approach to this honorable court. So and it's a Khasmal lease application, my lord.
Item 32, whenever your lordship pleases, I'm sorry, 34, whenever your lordship pleases tomorrow or can we have it tomorrow, my lord?
Great. The second half.
Great.
If any other matter is there, it is to be taken up. And please request it the other side and come.
I'm so grateful, man. So grateful.
Any other matter.
My lord, item 30.
Item
38, my lord.
We want
to intervene that.
Want to intervene.
You already served the copy.
In that matter, we'll be filing a rejoinder in 38. We'll be filing a rejoinder. Lordship may grant us whatever reasonable time your lordship grants.